It is not. But yesterday, when your lordship rose for the day,
Yes.
I was at para 59, page 28 of the note. I will not try and make good this point of incidental and ancillary. And will not how talking of ultra vires is to be a last resort. Subordinate legislation.
Yes.
Thereafter, my lord, I will only be placing the milestones and I leave the lordship to go through.
Sure. Which paragraph you want?
59, my lord, page 28.
Page 28.
Our shoulders kind. In my note, my lord.
नहीं
Title submission.
ये नहीं चाहिए कल के हमारा फोल्डर कहाँ है जस्ट अ मिनट मिस्टर विश्वनाथ
Even it's about the 41 page note.
लेट मी गेट दी
First requirement is to get the folder. The page will come.
हमने तो सबके ऊपर लिख भी देता हूँ मैं रख दीजिए
Only for the reports, my lord, of the All India Bar.
मेरे वाले कंपाइलेशंस भी दे दीजिए वीएन लिखा होगा ऊपर पेंसिल से
So that your lordship will find it easier.
Yes.
But my lord, the relevant ones I have extracted it in this. So that your lordship will have to get it in one page, one my lord, the document.
यू आर कमिंग रेफरिंग टू पेज
Page 28, my lord, para 59.
वेरी गुड
This is, my lord, to make good the point that when it says classes or category
Yes.
who are entitled to enroll, my lord. What will it encompass? It will encompass, my lord, certain ancillary and incidental things which are in furtherance of the object of the act. And we are trying to trace the power to hold the All India Bar exam pre-enrollment to that provision, my lord. Kindly see, my lord, how just one judgment, my lord, which also cites certain English authorities, I have called out in 2 pages. Kagaram Panchayat, instructive so-and-so, 1987, volume 3, Supreme Court cases 82. In our judgment, the view taken by the High Court that although the Panchayat Samiti was vested with the power to grant a license for holding of a...
Just how much time will you take?
But I will try and wrap in an hour's time.
I'm just for the convenience of your colleagues, I'm trying to test it out so that.
But after this, I will take your lordship again back to the proposition.
Between all of you, you are good for the first half day.
I think so. Because Mr. Advendu
We are appearing for the Bar Council of India, which I take around 45.
It also is,
also waiting
should be able to.
I thought you were waiting, so I thought the people are waiting for the next matter.
Your lordship cases, I can come back at 2.
I didn't
have
know.
this matter for you.
I know, we kept it not, we kept 3 days for these 2 matters, not knowing which one will finish.
Well, Lord, I'm ready. I've got my written brief with me. So I'll be happy to address the court anytime.
I think why keep you waiting? You come at 2 o'clock, we'll
But-
finish this first matter by then, I think, by lunch.
Much obliged.
Then we'll be ready.
Well, Lord, if I have your liberty, I'll file my amicus brief with the court staff.
502 alert.
Right.
Yes.
By 12, I think. 1987 pre-SCC, my lord, I was placing a very instructive paragraph, my lord, I find it useful, my lord, and I'm sure your lordship will find it useful too. I find it useful, my lord, and I'm sure your lordship will find it useful too. In our judgment, the view taken by the High Court that although the Panchayat Samiti was vested with the power to grant a license for holding of a hut or fair under section 117 of the Act, Yet it had no consequential or incidental power to specify a day for holding of such art or fair is manifestly erroneous and cannot be supported. It failed to appreciate that under the Act, the power of general administration of the local area vested in the Panchayat Samiti only to grant a license to hold a hart or fair under section 117 of the Act, but such a power of general administration necessarily carries with it a power to supervise, control, and manage such hart or fair within its territorial jurisdiction. The conferment of the power to grant a license for the holding of a hart or fair under section 117 of the Act includes the power to make incidental or consequential orders for specification of a day on which such hart or fair shall be held. The decision of the High Court runs counter to the well-placed, well-accepted principle. It overlooks that statutory bodies like the Panchayat Samiti enjoy wide incidental power. That is, they may do everything which is calculated to facilitate or is conducive or incidental to the discharge of any of their functions. And the doctrine of ultra vires is not to be applied narrowly. Pausing here, I am conscious of Honorable Justice Khanna's relevant observation that the opening part deals with the functions. What my lord pointed out on 49 was functions of the Bar Council of India. No doubt, the formal admittance to the register may not be the function of the Bar Council of India, but the power to lay down policy, is only with the Bar Council of India. And in pursuance of that, they have this power, which your lordship, will, my respectful submission, recognize it in 49(1) AG. It is well accepted that the conferral of statutory powers on these local authorities must be construed as impliedly authorizing everything which would fairly and reasonably be regarded as incidental or consequential to the power itself. See Dismith's Judicial Review of Administrative Action, Wade's Administrative Law, Gray's on Statute Law, Attorney General versus Great Eastern Railway, Baroness Venlock. Smith, in his celebrated work, Judicial Review of Administrative Action, puts the law tersely in these words. The House of Lords has laid down the principle that whatever may fairly be regarded as incidental to or consequential upon those things which the legislature has authorized ought not, this is the test, unless expressly prohibited, to be held by judicial construction to be ultra vires. The principle is enunciated by Lord Selborne in Attorney General versus Great Eastern Railway in these words. The doctrine of ultra vires ought to be reasonably and not unreasonably understood and applied, and whatever may be fairly regarded as incidental to or consequential upon those things which the legislature has authorized ought not, unless expressly prohibited, to be held by judicial construction to be ultra vires. These words have been quoted by Professor Wade in his monumental work Administrative Law and also by Trace on Statute Law. Trace also refers to the observations of Lord Watson in Baroness Venlock versus Riverdee Company. Whenever a corporation is created by Act of Parliament with reference to the purpose of the Act and solely with a view to carrying these purposes into execution, I am of opinion not only that the objects which the corporation may legitimately pursue must be ascertained from the Act itself, but that the powers which the corporation may lawfully use in furtherance of these objects but either be expressly conferred or derived by reasonable implication from its provisions. This court in VT Kanzode versus Reserve Bank has followed the dictum of Lord Selborne in Great Eastern Railway and reaffirmed the principle that the doctrine of ultra vires in relation to the power of statutory corporation have to be understood reasonably, and so understood whatever may fairly be regarded as incidental or consequential upon those things which the legislature has authorized ought not to be held by judicial construction to be ultra vires. It has been earlier laid down by Constitution Bench in State of UP versus Batuk Dev Pati Tripathi that a power to do a thing necessarily carries with it the power to regulate the manner in which the thing may be done. High Court failed to appreciate that the power to grant license for the holding of a hart or fair under 117 necessarily carries with it the power to specify a day on which such hart or fair shall be held. Such power to specify a day must be held to be a power incidental to or consequential upon the principal power of issuing a license under section 117 of the Act for holding the hart or fair. The rules or the absence of it do not detract from the substantive power, essence and content of the power of a Panchayat Samiti is issuance of a license for holding of the hart or fair and not mere maintenance of sanitation, health, hygiene. I would respectfully place this for your Lordship's consideration and acceptance that a measure intended to enhance the standard of the bar, which is why the whole Council exists, the primary object is that, ought to be read into a provision where it says classes or categories entitled to be enrolled. And if that is accepted, then Sudhir having placed the Bar Council of India virtually, my lord, subservient to the Bar Council of the state, saying that 24(1)(d) has been deleted. Now, how can you do it? Whatever you can do under 49A is only adding people who can otherwise be enrolled under 24. Gave a very large meaning to, my lord, I wouldn't call it totally ministerial, but the carrying out of the enrollment, as opposed to, my lord, laying down, my lord, policy perspectives in a very important, my lord, domain, which impacts, my lord, rule of law, independence of judiciary also, my lord, and, my lord, the administration of justice in general. My lord, with that, my lord, the next aspect of Sudhir, where, my lord, we trace this power to 7(1) also, my lord. BCI training rules, page 30. Hereafter, my lord, I'm only reading the crucial propositions. Leave it, note to your lordships to go through in detail. BCI rules could have traced.
Just 1 minute. The power and functions of the BCI are prescribed by Section 7.
Yes.
Section 49 is not prescribing the powers or functions. That's a rule-making section. Is that correct or incorrect?
Your lordship may have to read 7. There is one, my lord, residual clause.
That's fine. That's fine.
To
If
perform-
you fall under 7,
Yes,
last part of 7,
yes.
under the residual clause, then it can be taken
Yes,
over here.
yes.
But Section 49 by itself is not prescribing functions of the BCI. Is that correct or incorrect?
Provided, my lord, 7L is also given a leeway. Can your lordship see that?
No, if 7L you can get covered under the residuary clause, you are right.
Conferred on it by or under the act. Your lordship
The
knows
question
that
was slightly different.
Yes.
The question was, is section prescribing the functions of the BCI or section 49 is prescribing the functions? of the-
according to me, my lord, 7 functions, 7 sets out the functions.
Correct.
7, my lord, has supervision control over the Bar Council of the states.
Correct.
Then 7 takes your lordship to L, which says such other functions as may be conferred, not only by the act, under the act, by or under. And your lordship have made a distinction between the phrase by or under. State Bank is set up by the statute. Companies function under the company, are regulated under the Companies Act. So, my lord, something which is set up in the parent act itself. So, something which may flow from the act or under the rules. So, 7L, which, my lord, read with the supervision, control and the capacity to prescribe the entitlement to enrollment for the classes and category, my lord, squarely encompasses this power to, my lord, prescribe an exam to determine the entitlement, my lord, for the classes and category. It's going to be the respectful submission to your lord. Yes. My lord, that is what is developed here, my lord. So I'll read this, my lord, in detail at page 30, para 60. 7(1)(g) of the Advocates Act is an important provision which says that it shall be a function of the Bar Council to exercise general supervision and control over state bar councils. In fairness to the Sudhir Court, this provision was not pressed into service as one of the possible statutory pegs on which the BCA training rules, which had then struck down, could hang. However, the general supervision and control to be exercised by the Bar Council would include supervision and control over the ministerial acts performed by the State Bar Council in enrolling persons as advocates and maintaining the state roles of advocates. BCI function of general supervision over the State Bar Council would include the authority to specifically direct the State Bar Council not to enroll persons who had not undertaken the training course prescribed under the training rules. But this much could be said, that you will not enroll. If I have the power to prescribe the exam, I can tell you only if he qualifies under the exam, you can enroll. Because it looks like it is a pyramid, not a pyramid in that sense. It is a structure where Bar Council is at the apex and the State Bar Councils, all of them are below that. The directives come from there, and they carry out. They perform the disciplinary function, and if they are not able to finish it within 1 year, it gets automatically transferred to the Bar Council of India. If they finish the disciplinary proceeding, appeal lies. Now that 38 is provided, an appeal lies to the Bar Council of India. In that hierarchy, the Bar Council of India ought to be given a primordial role, in the scheme of things. In Hassan Cooperative Milk Producers Society, This honorable court analyzed the degree of supervision that is necessary to qualify a worker as an employee under 2(9) of the Employee State Insurance Act. At page 551 of the report, this honorable court stated that ordinary meaning of the word supervision is authority to direct or supervise, that is to oversee. The expression supervision of the principal employer under 2(9) means something more than mere exercise of some remote or indirect control over the activities of the work of the worker. Furthermore, the BCI function of control, or as the case may be, general control, not just appellate power, general control over state bar councils would also include a similar power or function. While interpreting the scope of the supervision and control to be exercised by the municipal commissioner or the petitioner corporation over the municipal officers and servants, this honorable court in Corporation of Sri Ramachandra held. It is thus now well settled by this court that the term control is of a very wide connotation and amplitude and includes a very large variety of powers which are incidental or consequential to achieve the powers vested in the authority concerned. The aforesaid case, suspension from service pending a disciplinary inquiry, has clearly been held to fall within the ambit of the word control. In a parity of reasoning, therefore, the plain language of Clause B of 59(3), as extracted above, irresistibly leads to the conclusion that the municipal commissioner was fully competent to suspend the respondents pending a departmental inquiry, and hence the order of suspension passed against the respondents by the municipal commissioner did not suffer from any legal infirmity. Also on the facts, but without supervision and control, vast powers. And to say that it has to be 24(1)(d) deletion also impacts 49(1) AG will be going against the scheme. Just see 7 once again. In 7, functions of bar council shall be lay down procedure, safeguard, promote, deal with, dispose of, exercise. G, general supervision and control over state bar councils. And I yesterday briefly touched upon the uniformity also. If every state bar council is to hold it, the standards will be different. And though it was deleted because the 2-year course had become a 3-year course, and now we actually have a 5-year course. How far it will be regulated will be up to them as far as training is concerned, but power to hold the exam cannot be denied to the bar council. If the respectful submission subject, of course, your lordships countenancing it. The idea is only to not to confine it to Hanilal Chulani's case. The Learned Attorney General rightly showed that passage where the learned judge granted this power to filter at the entrance stage, but the power is also otherwise prevalent and is scattered all over the Advocates Act. Kindly coming back to page 31, para 64. Thus, while performing its function of generally supervising and controlling the State Bar Council, BCI is entitled to require the State Bar Council to perform their own functions in a specific manner. As correctly observed in Sudhir, after the 1973 amendment, the maintenance of the state road and enrollment of persons thereof are functions of the State Bar Council. Equally, the 1973 amendment did not touch the BCI's function of general supervision and control over the State Bar Council under Clause G of Section 7. While supervising and controlling the state bar councils, nothing would prevent the BCI from requiring the state bar councils not to admit any person on the roll who did not undergo the training course prescribed under 1995. Hence, the judgment in Sudhir is per inquirium insofar as the possibility of sustaining the training rules on the touchstone of 7(1)(g). The Advocates Act is not just traced to entry 26 of list 3, it is traced to 77 and 78 of list 1. Even in Sudhir, 77 and 78 is the courts. Kindly see the constitutional entry. That though it's only the field, it is 77 is constitution, organization, jurisdiction, and powers of the Supreme Court, including contempt of court, and the fees taken, persons entitled to practice before the Supreme Court. 78. Constitution and organization, including vacations of the High Court, except provision as to officers, servants, High Court, persons entitled to practice before the High Courts. 26 of list 3, is the profession. So, it is placed on a very high, pedestal. Legal, medical and other profession is 26. So I would think, Milord, it is, the field is demarcated 77, 78. Also, Milord, 26. And it's a parliamentary statute. There is no state statute with any presidential assent, Milord. In any event, 77, 78, Milord, is persons entitled to practice in the high courts. It's an enabling power, Milord. If for any reason the Bar Council decides that no, the existing syllabi is enough, we don't want to hold the exam, Milord, it is fine. But today, Milord, they want to hold the exam, they are holding it post-enrollment. Milord, the page 32, Milord, would also answer what the Honorable Justice Khanna asked us. Page 32, paragraph 66 of the note. In Sudhir, this Honorable Court failed to appreciate that Section 7 of the Act bears the heading Functions of the Bar Council. The list of functions under the various clauses of subclause 1 is clearly not exhaustive. Prima facie, the opening words of subsection 1, the functions of the Bar Council shall be, may invite the interpreter to say that BCA shall only perform the listed function. However, the impression is dispelled by clause L and M of the subsection which are couched in wide terms. M also says to do all other things necessary for discharging the aforesaid function. Clause L says that it shall be function of the Bar Council of India to perform all other functions conferred on it by or under this Act. Thus, the said clause contemplates that there could be other functions conferred on the Bar Council of India not only under this Act, that is by rules made under this Act, also by the Advocates Act itself. Thus, a full list of the functions of Bar Council of India must be gleaned from the entirety of the Advocates Act, not only from Section 17. In fact, the function as distinguished from the general power of the Bar Council of India to make rules pursuant to 49 of the Act must be traced to clause L. There is no other specific clause in the list which enables BCA to make such rules as is empowered to make under the Act. Clause M takes the remit of the Bar Council still further and confers on it the function of doing all other things necessary for discharging the aforesaid functions. So it has to be linked to the above functions. Kind of wisdom will not would apply. It is submitted that this clause by way of abundant caution expressly confers incidental and ancillary functions of the Bar Council. Statutory functions of the Bar Council to do anything is calculated to facilitate or is conducive or incidental to the discharge of any express functions. If we can exclude the paragraphs which already have been conveyed. Kindly come to Note 70. On 24(1) itself, an additional statutory function of the BCA can be culled out from 24(1) of the Act to lay down conditions subject to which any person must be treated as qualified to be admitted as an advocate of the state court. Statutory function can flow from provisions other than 7. Next, submitted that one such function may be derived from opening words of 24(1), subject to the provisions of the Act made thereunder. The person shall be qualified to be admitted as an advocate on state road. Doubt whatsoever as to who reigns supreme in the hierarchy between Bar Council of India and the state bar councils. 71. Expression rules made thereunder would take into its fold all rules made under the Act, not only rules made under the State Bar Council under 28(2)(d). Satish Kumar Sharma. The conclusion is Sudhir to the effect that 24(1) read with the rules made by the State Bar Council under 28(2)(d) would constitute a complete code with regard to admission cannot be sustained. Further submitted that on a conjoint reading of 7(1)(l) and 24(1), Advocates Act confers the BCA with the statutory function of prescribing rules subject to which any person may be treated as qualified to be admitted as an advocate on the state road. Therefore, surely, such rules may lay down a condition that a candidate may not be qualified to be admitted as an advocate on a state road unless she has undertaken a pre-enrollment training course or exam prescribed by the Bar Council of India. We, Sudhir, to the extent that this statutory function was not considered by this Honorable Court as a legal basis for the BCA training rules, the decision requires to be reconsidered. Then, Milord, rule-making power under 49(1). Just come to 75, Milord. I don't want to read the rest. I've conveyed it. para 75. Even if the Honorable Court concludes that no other provision of the Advocates Act confers the Bar Council of India with the function of laying down a pre-enrollment condition, clause AG per se offers the basis, my lord, subject to what your lordships ultimately say. Then, my lord, 49 is a general rule-making power. Kindly come to para 78. I don't read the other paragraphs. Page 35, para 78.
Mr. Why don't you take into consideration AH also? Does it not in any manner help you in your submission?
The condition subject to it, advocate, my lord, shall have a right to practice. So the argument is that it's post-enrollment.
No, condition subject to which, so therefore, what is being put to you is,
Yes.
enrollment may not give you the right to practice. And the Bar Council can impose conditions before you can actually practice.
Your lordships are saying enrollment is one part,
Correct,
practice is the other part.
correct.
Exactly. Because state bar council deal with enrollment only.
Yes.
Everything else is with the
With the
DCI.
Council of India.
And one more thing, if we accept your arguments, there is no difference between rule-making power, which confers power on the Bar Council to hold examination at pre-enrollment stage and post-enrollment stage. The reason is Section 30 can be always explained. Section 30 is again subject to the other provisions of the Act. The power which you want us to read into the Act, we read into it. Then it,
Only thing.
whereas both the things, both the examination, pre-enrollment, post-enrollment, that can be justified. If you see Section 30, it is again subject to the provisions of the Act.
Only act, my lord, not
But
rules.
rules are framed under the Act.
My lord,
If Act permits,
some rules, your lordship knows after, my lord, it's tabled, it is treated as part of the act. Some rules don't have that, my lord, provision of tabling and being part of the act. 7L says by
And-
or under the act.
no, as Brother Justice Khanna
Yes.
said, that condition can be imposed. You may be enrolled,
Yes.
but you can't practice.
Yes, my lord, this passage
So
is,
there, you perhaps the post-enrollment exam may also fit in.
yes. The definition of advocate, my lord, which my colleagues want to bring to your lordship notice, but that is only post-enrollment. But pre-practice, that's what.
everyone is arguing for Mr. Mishra. आप बैठिए भाई.
Advocate means an advocate entered in any role under the provision of the act.
Another aspect would be
Yes,
to see section 29 and section 30.
yes.
Section 29 language is subject to the provisions of this act and rule made there.
Rule made there.
And if
So
you see
advocate-
section 30,
Is only one who is
then
entered
it is
in the
only
role.
subject to the provisions of the act.
That's correct. Your Honor. That is why the problem in sustaining the exam, post-enrollment without statutory backing.
So fortunately, somebody is saying that post-enrollment exam, provisional enrollment exam is not permissible.
Similar, Mr. Seth is here. with-
Okay, we'll hear him out on that. We'll hear him out on that.
The problem is that I can, Mr. Mission, I can do it this way, do it that way. Somebody will come and do it this way, do it that way. Ultimately, we must cut
Have,
down how we hear bar council, right? What do they want to do?
Yes.
We must pen down one now.
Question whether we should give him that freedom.
You see, the point,
Pre-enrollment solves whole lot of.
Brother rightly put it, that should that much of freedom be available to the bar council?
You know, pre-enrollment brings about, you know, total conformity with the act. This section 30 problem.
look, if,
Without parliament having to step in, I
Let's-
want my out to do.
I have some issues, I'll flag them
Yes,
once you address, as how in a pre-enrollment scenario, while thinking about it with some assistance, how something will work out. There are some concerns.
we will, you know,
If you
definitely.
want, I can put it now to the bar council.
Yes, we will reflect and come back
So,
towards the end of the submission.
One of them is will be, what will be the date of seniority to be determined in this framework? You
Yes.
go for a pre-enrollment one. So what will happen is the senior, you are not entered on the bar rolls, correct? You take an examination. Result will be declared on a particular day. This is the passing examination. You don't give marks that somebody has got 80%, somebody has got 70%.
eligible.
Now, it's an eligibility exam. So what will be the seniority in terms of this framework? It is important.
They have enrollment. After exam, he goes and enrolls.
So let's see. After the exam, he enrolls. When the exam results are declared, people enroll. There will be hundreds of people enrolling on one day. So far, what happens is people enroll on different days. And hundreds of people will enroll on one day. How the seniority works out, I'm going to understand each chamber allotments. Issue
Yes.
can be at the stage of elevation. How do we work it out? Practical issue of working it out is dealt with in your mind. One, I'm told there are different frameworks for taking examinations. So, what would be the prerequisite to take the pre-enrollment examination? At the moment, I'm told the candidate is required to submit a copy of the provisional main degree to get themselves enrolled. Will it the same formula which will apply? How will it apply? Eligibility. This is also, of course, in the context of different universities issuing at different times the degree, which is a logical consequence. Between the period when they clear the examination until they take the bar examination, is there some role to be assigned? Can they do something? Otherwise, you will have what you do with law graduates intending to become lawyers, completely unemployed.
Actually, this was the aspect I was discussing with Mr. Viswanathan in the morning. That pre-enrollment, that will create a lot of pressure. The students,
Something has to be, there are practical issues. One is the constitution issue, one is a practical issue also.
No, correct.
And one aspect flagged was apparently that different state bar councils do not follow uniform practice. For example, they have to become, let's say, they have to become their member of the state bar council. Each association has its norm how somebody becomes a member of the state bar council. I am told that there are different fee structures,
Yes.
different norms. Some of the places, the fee structures prescribed as high as 15 to 20,000 to become a member of the bar council. Some of them they are less. How? So there are some young law graduates are expressing concerns. How will should there uniformity be provided in this? So let's look at somebody who's coming from more rural background, etc. To enroll in Delhi, he may have to shell out 20,000 rupees to even become member of the bar council. Powers of the state bar councils. But is this not a little troubling aspect?
No, Melody, it is.
So in my internal discussions, these are 4 facts.
No, Melody,
Right.
it is an important aspect. But one more which flows from your lordship's order.
present, how do you do it? See, one issue, of course, we are digressing a little, but
Yellow minute is all.
part of the Bar Council, part of the enrollment committee says that we used to collect, the applications are collected. When the enrollment committee sits, it clears, say, 20 candidates. Then all 20 of them would be enrolled on the same, treated to be enrolled on the same day. In that, it moves alphabetically, apparently. Is that correct?
No, it was not alphabetically. It was not alphabetically. It is being numbered. Number is being given. Whatever the numbers, sequence number of that year. No. In general, these forms came. Number is given. Registration number is this. So from
Date of submission of the form would be relevant then.
No, that was not there. It was only whatever the number is given. Suppose the number is 1027, 1028. So 28 would be below. 29 would be,
Application number or?
it is a registration number, enrollment number.
So registration would be, I take it by the fact, when the application is submitted.
It was there, but in general, what I have seen, what I experienced it,
It
whatever
depends upon
is
the,
given by the bar
it is
council,
at
that
the-
is seniority.
Problem. When we were enrolled, it was on the same day, it used to be in Delhi alphabetically.
Maharashtra Bar Council also.
Different state bar councils have
Also
different,
Maharashtra also alphabetically.
Alphabet.
different state bar councils have different rules. But seniority is decided as per the date of enrollment. And if the date of enrollment of two advocates is the same, then not the date of birth,
The date of birth.
that decides.
So the older one will be made senior.
Malu.
This is actually I think the greatest concern is now is chambers for lawyers everywhere.
Yes.
So therefore, this is one issue which arises. Of course, in a relevant stage, it can also be for seniority in judicial service. That can also arise. Not in judicial service, but for high court appointments. And brother says there's an example which had occurred at some stage on this issue of. So you will.
But
That's
one
what I-
simple thing I may submit. If the power, whether we can put some conditions pre-enrollment, some conditions after enrollment below as per AG and AH, if that is decided,
What we are saying is, suppose, let us say, were we to agree with you. Say a pre-enrollment examination take place. We don't want another litigation to arise as to how it will work out.
Mr. Sudhant Kohli, assisting the Canada Attorney General, rightly, my lord, draws my attention to section 21 of the Advocates Act.
There is the age.
Where the disputes regarding seniority, where the date of seniority of two or more persons is the same, the one senior in age shall be reckoned as senior to the other.
that is what I
This
said.
is for same date enrollments it should be.
Yeah.
The object is supposed to, if any dispute arises with respect to the
This again is a little issue.
tiebreaker rules have to be.
No, that's again a issue. Suppose two persons given the application on the same day, one person's application is considered earlier, the other person's application is considered later. Just because of that fortuitous fact,
Yes.
he may go down. And today when there is
That fortuitous fact always arises, I was telling my brother, and it will always arise.
one way to look at it is, whoever is enrolled within period of say 3 months, their seniority is be determined as per. Because most of the enrollments take place sometimes between August and October. Is that maybe because the results are declared?
They do it by.
Now they do it by separation also.
Everywhere.
Earlier we had to wait for.
But Madras, they used to sit in the bar council, and there is a kind of an oath kind of a thing also, not for law.
Anyway, this is not
I
subject matter before.
And they would have fortnightly sittings.
Similar type of procedure is there.
This arises from each state bar council having a different fee, a different this thing, all other things are different.
There has to
Is there a power in the bar councils to have uniformity? Asking the states bar councils to some uniformity in this process of enrollment.
7L supervision, 7 will not, supervision control. Directly will not do. This much they can do.
48B
Not uniformity, 15,000 will not in some cases and completely will not it is.
We can issue direction under section 48B also.
It is varying up to, even up to 20,000 enrollment subjects.
But 48B, 48B may not also, my lords may kindly have a look
Yes,
at.
hardly enrollment, will not is derailment.
No,
20,000.
It's not express was
No, okay.
50,000. And it's a large sum of money. So can there be a thought process? Can there be some uniformity in it?
To be.
Some range in it? This is a small capitation fee.
So they permit transfers also.
Yes.
They permit transfer and they assign a capital A, like in my case. We enrolled in Madras, transfer to Delhi. I don't know whether they charge the difference as me, I don't know, but we were given transfers.
That is under section 18 of the act. We have got the power.
48B is a power, and we will look into this aspect.
And we can look into all these aspects under section 48B
Power to give directions.
or to
We
issue.
have a separate registration for separate senior advocates also. We upgrade or something.
It is section 16.
16.
Provides for separate.
Seniors,
We have
16, that is a different chapter, not for senior.
Brother was asking, even there you ask a fee or not?
No, no.
I said, I
Once a person is enrolled, not, we
I
don't
don't
charge.
remember I paid something or not.
No, there is a fifth issue to what your lordship mentioned.
Just 1 second.
Right.
You see, very interesting, is section 30. Section 34(1).
Also.
Section 34(1). Mr. Vishwanathan,
Yes, ma'am.
section 34(1).
Yes.
Laying down the conditions under which an advocate shall be permitted to practice in the High Court.
Report subordinate.
And Article 145 for the Supreme Court.
The High Court can frame a rule saying that you must undergo some kind of examination
145.
before you practice.
Yes, yes. 52 Supreme, you quoted 145 also in the Constitution.
A few years back, my lord, the Patna High Court made a rule that for AOR, that you will have to appear in the exam, only then you will be entitled to practice there. Sign the Wakaltama and all that.
So section 2 of 30.
Few months back, they have withdrawn it.
Calcutta की
But
section पर होगा.
that rule.
Intermediate and final examinations.
No, now it doesn't, because there is nowhere, in no other high court, there is such rule. That is why they had to withdraw it.
No, that rule is there. For example, on the original side of the Bombay High Court, unless you enroll yourself, you can't file Wakalatnama on the original side.
My lord.
You need registration as an advocate on the original side. Perhaps that is referable to this 34(1).
My lord, 34.
The rules provide for it.
Allahabad High Court has also such.
Yes.
rules.
Unless you are
Upheld by this
the role of the High Court, you cannot file your wakalatnama. They will not be accepted.
My lord, my lord, my lord. That has been upheld by this court.
Yes.
Because the advocates on record here system, under 145 1A, challenge upheld.
Okay, yeah.
Because there are some, they have to have an office within 16-kilometer radius for service. And we are there. So they are the ones who are more directly in touch with the history of the court. The fifth aspect which my lord mentioned flows from the order of in Twinkle. Suppose is enrollment of an advocate, right? He suspends it. And he takes up an employee related to law. He's a prosecutor, he is deemed an advocate under CRPC 24. Suppose he becomes a stockbroker. And after, my lord, 15, 20 years, says, now I'll go back to the bar. There, my lords, Honorable Justice, from a suggestion that exam under AH can be insisted because he has been wholly unrelated to my lord.
Yeah. I know more than one case where a person would clear law, that time exams do not exist, enroll himself in the bar, and then suspend the license to take up the job. They used to always say that, our process of enrollment is completed, so that at least we can come back if we don't. That used to happen even then.
But my lord, if he is doing a job allied to law, even a legal officer, group counsel, no problem. But suppose unrelated, suppose he's been in business. Right, straight away entry, my lord has said, yeah.
Practically can happen. I don't know how many.
Yes, but your lordship in the other order said, if
Yes.
there's a 5-year hiatus,
That we have any case said in that.
exam again.
Lord, in Twinkle's case, my lord will remember that we have taken care of that, such persons, that they will have to appear
That
again.
I think anyway they will have to, that rule has to
Any
be.
case goes up, directions pass, you have to structure that also.
Structure that. No, my lord, the Honorable Justice Pranath drew attention to 49 AH, that is not very relevant because there are different categories, my lord, for which exams may have to be expected. 20 years not related to law, he is coming back and says, now I revoke my suspension of practice, I want to practice. He's holding out to the public as lawyer. Right of audience in the highest court.
Some litigants became lawyers while processing their own cases also.
And some lawyers became prolific litigants.
So these 4, my lord, will reflect and have to be permitted to practice in the High Court and the court subordinate thereto.
This rule probably, subject to what Mr. Mishra have to say, will only apply in case you are already enrolled as an advocate. So it will be going by that process, then probably the High Court rules may prevail over the,
Bar council.
because you have to be first enrolled as an advocate, then only you can put the condition. Of course, whether the condition is reasonable or something,
Will be again subject matter of litigation.
that is something separate.
And AH and the 34(1) will be harmoniously construed in a way that for that High Court, you'll have to still comply with that. For the rest, you'll have to.
Otherwise, all the high courts where they have framed rules with regard to the right to file wakalatnama and practice will become into an issue.
You raised this issue, Mr. Vishwanathan, because much as I don't like supplementary notes and supplementary notes of synopsis, you'll have to give 1 2-page note. On the issues raised in the court, including some of the issues which I have flagged, issue of interplay. In the discussion, some things have emerged.
Yesterday's issues, my lord, there is a 2-page, but these 3 are today's. My lord, so give me a day. There, I was going to give a 2-page on yesterday's. That is ready. My colleagues have ready.
Give us your board days.
Yes,
Instead of giving
I'll
us
give- I'll give
yesterday and 2 pages.
I will factor in these 4 also. My lord. We had factored in the AH issues.
The AH issue also, if some, see, what emerges from today's arguments
No, my lord.
is, will make us all, I think, a little wiser.
Yes,
So, or at least throw up ideas.
definitely. My lord.
So, by the time we conclude, this is a rare case where I would like a 2-page or 3-page note after from what emerges from these arguments.
Yes, we will definitely give you lots of.
So that has different kinds of ramifications for the legal community.
Yes.
Okay.
Milord, and just Milord, I have made my points.
And Mishra, you're also, who is representing the Bar Council? You will also have to give a short note,
Yes,
give us pieces.
Not will
Yes.
do.
We also have prepared by indicating that
We don't have multiple short notes, not possible. You do it, but we'll hear you all, but this can't be that you, everybody writes a short note. Give it to us, then we calculate the short notes and combine it. We'll see the second case after we've done. We'll see what you have to say.
Very much.
If
Look,
you
the
say
rest of-
something additional, we'll look, otherwise they're not going to look.
That's what I'm saying. No, the rest of the
When we
pages
say
are.
additional, but whether it is additional or not, let us take a look, otherwise, the judgment writing itself becomes a cumbersome exercise.
I'm just going to finish this segment by reading para 78 because rest has been highlighted, not trashed out. I don't have to read paragraphs without that.
Yeah.
What 78 alone, Milord, as to how one cannot tag on 49 1 AG with 24.
Yeah.
Alone. That will be, Milord, the last on this presentation part. This apart, it is humbly submitted, page 35.
Yes.
That the decision of this honorable court in V. Sudhir was not justified in shoehorning the rulemaking power under 49 1 AG of the Act to certain specific provisions of the Act. Firstly, the honorable court held the power under 49 1 AG is only ancillary to the statutory function entrusted to the Bar Council of India under 24 3D of the Act. Finding is based entirely on the fact that both these provisions were introduced by way of the same amendment of 1964. 24.3 provides that notwithstanding anything contained in 24.1, certain categories of persons could be entitled to be enrolled into the Act, and 24.3d specifically states that a person could be made to be entitled to be enrolled as an advocate under any rule made by the Bar Council of India in this behalf. Further, the said provision states that these persons who are identified are to then follow a specified procedure under the section in order to be enrolled. So clearly, the section which empowers the Bar Council of India to specify certain category of persons to be entitled to be enrolled. 49 1G does refer to the class or category of persons to be entitled to be enrolled as advocates. Over the restricted reading given by this honorable court in Sudhir will not be in line with the scheme and purpose of the Act. Rather, the reading of this provision should be that the rulemaking power under 49 1 AG will be exercised to determine the persons who will be entitled to be enrolled, and this would include the category of persons who either undergo a mandated training or examination. Thereafter, once these persons are identified, the ministerial act of enrolling such persons subject to conditions that will be specified is carried out under 24 3D of the Act. This harmonious reading of this provision would be in line with the delineated functions under the Act, which relate to the maintenance of roles with regard to State Bar Council and the overarching power to determine those who are entitled to be enrolled. Because Sudhir said 49 is read to be in the context of 24. Lordship may see 24 for a minute. 24 in the Act. So that, yes. Subject I have read, 24.3 is over the page, my lord. Notwithstanding anything contained in one, a person who has for at least 3 years been a vakil, etc., 1st December 61 was entitled. Otherwise, these are, my lord, people brought into the Advocates Act, the pre-61 practitioners. D is entitled to be enrolled as an advocate under any rule made by the Bar Council of India in this behalf. This and classes and category can be harmonized. The Sudhir felt that anything in 49 1 AG should be in furtherance of this D. You could add categories, not prescribe an exam. This is may be admitted as an advocate if he makes an application for such enrollment, fulfills the conditions specified in A and H. So, my lord, this is to bring in pre-61 wakils, pleaders, muhtars before 1st December entitled otherwise than as an advocate to practice the profession of law. C, before the 1st April has been advocates of any high court in any area which comprised Burma, or is entitled to be enrolled as an advocate in any rule. For example, this has to be adjusted with A, B, C, any category left out. Now that we are making a consolidated act of 61, these three plus is entitled to be enrolled as an advocate under any rule made by the Bar Council of India in this behalf. This certainly has to be, take its color from A, B, and C. This will not detract from, the overarching power under 49.
Just one thing over here. 24E.
Yes.
He fulfills such other conditions as may be specified in the rules made by the Bar Council of India under this chapter.
Yes.
Now, the general power of superintendence is with the Bar Council of India.
Yes.
They can issue also directions to them.
Yes.
Cannot then the Bar Council, taking advantage of this, issue a direction that the before enrollment?
Yes. Yet you will not enroll anybody who has not passed the exam. That is how it has to be read. Not that whatever you.
So therefore, what can be done is, the Bar Council has general power of superintendence.
Yes.
In that exercise of general power of superintendence, then the Bar Council can issue directions saying that that till this condition is satisfied, the State Bar Council will not enroll anybody, and therefore the State Bar Council have the power because they can impose other conditions other than the conditions mentioned in A, B, and A and B.
That's correct. That is how one has to read it.
But this will be dehors the arguments which you have already.
Yes, dehors the argument. Dehors the argument, and will not.
Sir, that power I have in 48B.
Yes. But Lordship, there will be more than adequate time. The rest of the note, my lord, is there is a segment on post enrollment. I have already argued at page 37 onwards, page 40 onwards. My lord.
But the only difficulty is with what is the effect of withdrawal of that clause, because then 4D.
That will not affect the 49(1) AG power, my lord. In fact,
Oh.
it brings about uniformity. Just imagine, my lord, the 25 odd bar councils framing their own rules would be chaotic.
Ethics and reasons also. Deletion of clause.
That is
just debating the issue of pre and post. If post examination, as long as they are pre enrollment is there, they are entitled to take up jobs subject to in law firms. They're entitled to join as law clerks. They get emoluments. We say that a pre-examination, then till they don't clear the examination, it cannot be enrolled. There will be again a hiatus period when they do nothing.
No, my lord, law firms take.
My brother rightly put it on one hand, they seem to be concerned by 15 or 20,000 rupees as bar council fee, but on the other hand, people who are by joining firms, by joining lawyers, getting stipends, by joining judges, law clerks are also many all over the country. How does one do it?
No, my lord, the placements happen in college before even their final exam, and they join, and they take their own time to enroll. Depends on how much enthusiasm they show to enroll fast. Otherwise, my lord, the fifth year.
Or the people who are working with lawyers, so people who work with all of you.
Yes.
Is it that the emoluments, you may not be the right example, but people who join the profession and they start working with somebody, is it that they have to clear the,
No, my lord, those who are able to find officers.
presumption
All
is
that is required is they have passed the exam and are awaiting enrollment.
but all that will happen immediately is that people, as of now, I can take example of law clerks. Somebody graduates law, you take this provisional registration, he's eligible to apply for law. We say a pre-enrollment, will he be eligible to apply
No,
for law?
but all the, your lordship can take it from me. Your lordship may get news items in the law portals about so-and-so university has had 68 placements, 70 placements.
No, those are different.
On that
There's a very minuscule top of the league people who are getting a placement in the,
Yeah,
maybe
that's
sometimes
choice
in the
law.
corporate side also, in companies or get, so that we're talking about 50 law schools. Maybe 50 or little more.
Even in litigation firms, except that since they have to
Dealing with
wear the
ordinary
badge.
law colleges.
They constitute only maybe 10% of the law graduates who pass out every year throughout the country.
Even less maybe.
Even less maybe, huh? They all go to district courts and different high court and
I
talukas
was
and
just
commissioners court.
testing it today what happens. The person has to apply, let us take a law clerkship. Any judge here or in the high court. What happens is we say, okay, you get your first enrollment done. So they clear the exam, obtain the certificate, get a preliminary enrollment done, and then they're eligible to work as law clerks. Now, this is one more aspect which cropped up, that suppose it is not so. Suppose there is the exam to be cleared before your enrollment can take place. Then they would be eligible to come as law clerks only thereafter. Unless we amend rules that all over the country that is not there. And the problem which will also arise would be that different universities come up at different times with their results. Suppose somebody comes up with the results in September or October, and you are having an exam in October or November. Now, he may or may not be eligible in such a short time to be able to complete the formalities to take that examination. Then goes to March or April.
That will not, they have to hold exams at least
Twice a year.
twice.
You can't ask them
Maybe
to hold it every month. So twice a year they are supposed to hold it. Twice a year they will hold it.
No, actually,
I even personally debated in my mind for even enrollment purposes. For example, whether though it's a qualifying examination can be take their marks for enrollment. Because again, another complication as my brother put it. So,
Marks with different strata, people come from different
yeah,
backgrounds.
so the exam itself is actually an eligibility exam.
Yeah.
As long as they have the cutoff,
Yes.
that should be allowed for.
So that was from enrollment point of view. It is also troubling us is this, if we confine it to,
But in fact, the legislative competence of Bar Council of India, as per the Act, that is to be decided. Humble submission before my Lord
we
says.
would like the widest amplitude of power. Of course, certainly.
My Lord, the Act has empowered us
That's fine.
to,
What do you want to do? I'll come to you. What do you want to do ultimately? You want to have a pre, you want to have, which according to you is a better solution? You can't have pre now, post then, pre, post. It can't be vacillating.
that we can't do. My Lord, post enrollment is already going on. It's a well-tested, my Lord, formula. And therefore, we are compatible with it. Pre-enrollment, certainly that will, my Lord, have a separate ramifications. We'll have to study
That's
whether
the
we are.
problem. So I take it your argument is only leave it to us to hold a pre or post after we
My
are
lord,
putting
my lord.
a post enrollment examination at the moment. We will continue to hold this. If we have to switch over to pre, we will have to consider all the ramifications.
My lord,
Is that what you are saying?
my lord.
That's a change in standard.
It is simple submission.
Your lordship's rules only require.
Pre,
We have just taken from the website. Sorry, 1 minute. The candidate must be a law graduate as on the date of appearing at the interview having a bachelor's degree in law. From any school, college, university established in India and recognized by the Bar Council for enrollment as an advocate. This provision is not insisted, the rules from your lordship website for law clerks.
So, no, but enrollment, eligible for enrollment.
Eligible for enrollment.
How is he eligible for enrollment once he has not taken the examination?
No,
Put a pre-exam.
law school has to be recognized for enrollment.
Of course.
That's all they need.
No, for law class, the last test our norms. You are reading from our norms, like.
Yes, revised for your
Now,
lordship.
in the revised scheme, you are eligible for enrollment.
No, from a law school, I'll read that again.
Just read it again, please.
The essential qualification, clause 6. 1. The candidate must be a law graduate, bracket, as on the date of appearing at interview, bracket close, having a bachelor degree in law, including integrated degree course in law, from any school, college, university, institute established by law in India and recognized by Bar Council of India for enrollment as an advocate. So the institute will should be recognized by them, saying if you pass out from this institute, university,
There is no requirement, there has to be a
provisional enrollment.
provisional enrollment.
No, that can also be taken care of by one other way.
my lords have talked of, so many engagement in law firms and different fields also. They never accept without enrollment.
On a practical plane, they always say, don't mess with something who's working there. That's another problem, a very, very practical thing. After great effort, has this system been fine-tuned as to a post-examination, various things, we pass directions in the other matter, we try to do. So we understand there's a constitutionality to it, which we'll look into, which we'll have to look into it. But
In a given scenario where they want to hold it, and they say, all right, we will not inconvenience students and delay, we will even permit them to appear in the middle of the 5th year. Like many foreign exams are held. You don't have to wait for the last exam. If you have passed 9 semesters in law, always people who are dead serious, if they want to do it, they want to do it.
see, we are talking about places where the number of people are how many? Talking about India, where we are talking about 1,500, 1,700 law schools. I don't even know if the whole of Europe has so many law schools. So, this is the system. In our, everything is a number game. Whether it's courts, whether it's hospitals, the numbers are too large. So, we have to structure things according to the numbers which we are facing. Therefore, is it your say that Sudhir is wrong because it says pre-enrollment cannot be held?
Cannot be held at all.
One.
How they hold it, take care of this, real ground reality.
That's one. That's your argument.
That will happen if there is a challenge to the subordinate legislation. And they are told, look, this is the inconvenience we have put to. Lordship will
That's different. We don't want unending litigations also on this. We spend time, we want to fine tune it. But Is it also your say that post-enrollment examination needs a legislative change? That is what you were seeking to contain.
That is, you know, how it is structured, because it does say act, you know, to basic as it is, because
Look, if we accept your argument, that
will not, I will convince. Maloo.
We'll hear you, don't worry.
Maloo.
if we accept your argument that deletion of subclause D and 28, deletion in 28 is of no consequence as far as powers of the BCI is concerned, then the BCI, in view of the general superintendent's power which they have over the state bar council, they can issue directions to them that please only enroll after you can. Or in terms of 49(1), AG also again, they have the powers that even if you are enrolled as an advocate, your right to practice will be curtailed till you satisfy those conditions. Both the situations.
You were,
I'm not saying the other matter.
actually, the other matter, practical purposes, tweak to take us ourselves out of, so they need to work it out in a way.
You also made a distinction between right to sit for the exam and right to practice.
Another aspect is, Mr. Vishwanathan, another aspect.
Accept his argument, we have to also accept that.
So that is a class and category for the advocate.
That's right.
This is one. And the
Entire-
another is, one H is to practice.
Yes.
So that is a different category. So for the purpose of the practice, you can put an embargo, whatever it is.
Yes. So my lord, so ultimately, my lord is perhaps suggesting that while classes and categories entitlement, you
So
can.
what may be a class and category, they can specify.
They can specify.
For the
and-
purpose of,
And they can also specify, having enrolled, how your practice
yes,
can follow.
yes.
That interregnum between enrollment and practice, if they say you must clear this, you can clear
So
the.
that is the, if we see section 6 also, the function of the State Bar Council.
Yes.
It is section 7, function of the Bar Council of India.
Yes,
Then what are the powers to the State Bar Council? 24(1) for qualified to be an advocate.
yes.
So this is one condition. And for the purpose of advocate, this is a different condition.
So there is another way of looking at it. Now that your lordship mentioned this. There is another way of even looking at it. All that will be required is in AH. Since the definition of advocate is only
Only-
subject to the context of the country,
Only to be enrolled.
enrolled.
That's all.
So
Now,
you-
after that, the right to practice comes.
Correct.
So AH comes into play there. council.
Argument that the overarching power of the Bar Council of India is not clear. Along with this clause, PA seems to give them an overarching. If this overarching power is taken into consideration, then at what stage the Bar Council exam takes place, whether before or after,
It doesn't matter.
doesn't make a difference.
Yes.
Of course, it means
No, I'm only suggesting one more in that line, my lord, which,
the lighter side, Mr. Mishra, should we empower you so much or not?
there is one more way of looking at it, in furtherance of it. Can you see the definition of
One method is to trust the Bar Council. Let them decide the nitty-gritty or whichever way. Our concern is there has to be an exam that we are certain.
agree on power?
Number two, that exam must be of appropriate level. We are pushing in the other matter.
Yes.
That Justice Naveen Sinha's committee, they were appointed, are looking into it. Hopefully by next time, the exam will be there. Should we embark on the issue of necessarily a pre-enrollment exam and look through all the consequences which may arise in that?
No compulsion at all. No, can't be compelled, only enabling.
Yeah, that's what I think. So, or should we leave it to the Bar Council, in which case they will look to the consequences of either shifting to a pre-exam or post-exam. And we confine ourselves to the constitutional issue in this case. That is the view that only a pre-exam can be held, good or not? If it is so, then only a pre-exam can be held. If it is not so and both are possible, then a pre-exam or a post-exam can.
Yes.
Since it affected a large number of bar members, these thought processes have emerged. We are conscious that all of them may not be required for the constitutional interpretation.
Look, there is one more
It
thing,
affects the bar at large. So,
just to take what has fallen, my lord, now my lord, articulated by my lord, going back on the invalidity of the post bar. If your lordship sees the definition of advocate and read it with 30, there is a way to reconcile this. Kindly see.
you are referring to section
2A,
Way.
read with 30.
here.
Your lordship sees all definitions are subject to a context, unless the context otherwise required. As long as there are clauses where you fit in this definition. In certain clauses, your lordships have freedom to depart, but based on the context. All that should happen is there should be some clause where the definition applies. It can't be that you just apply the context contrary to every clause. That's the law, not on unless the context otherwise. Advocate means an advocate entered in any role under the provision of the Act. And 30, if 30 is to be, my lord, seen as a hurdle, right of advocates to practice, subject to the provision of this Act, every advocate whose name is entered in the state roll shall be entitled as of right to practice,
Yes.
no doubt. Now, AH, condition subject to it, an advocate shall have the right to practice.
And the circumstances.
Yes, so this advocate, my lord, can also mean who is entered in the
Role.
provisional role, not necessarily the final role, because he's still not entered in the final role. So this advocate in AH, tying up with what with 2A and 30, and the right to impose condition to practice can also mean, my lord, an advocate who is entered in the provisional role, so that, my lord, they provisionally enroll, and then take out their time to write the exam as prescribed by them. So that, my lord, the 30 problem is also taken.
Another general aspect of the right. Legislature enacts an act. One looks to the overall arching objective.
Yes.
Is it possible for legislature in these kind of cases to envisage of every mindful possibilities and abilities of lawyers' ingenuity to take into it? There is a overarching role assigned to the bar.
Correct.
If that role is assigned, unless the legislature wants to hedge in the power
With a prohibition,
with a prohibition,
which is not,
any interpretation which gives rise to
yes,
a continuing role envisaged for them should be permitted.
Incidental
A
incident.
structured,
Come back to Karnal
Structured act.
Panchayat's case.
structured act.
Okay.
Yeah,
And the
that's
whole
some-
foundation of delegated legislation and
And
conditioning.
giving intent to the removal of the section 34. Vis-a-vis State Bar Council. Even if you look at an objective, it could be justified by saying that every State Bar Council starts prescribing different standards. And the consistency of standards prescribed by the Bar Council of India will be affected. So it is with that objective it was deleted. Is it that they say no, Bar Council will not control the standards of profession? No. Then what are ultimately what is the exam doing? It is controlling the standard of the profession. It is prescribing the standard of the profession. That somebody must, and in a law school where varying degrees of proficiency exist in the law school, you have a common exam to see that people do reach up to at least certain benchmark to be enrolled. Right? So they are lucky in the profession. It's not a civil services examination. But you must be able to do justice to your client and assist the court in a reasonable manner.
That's correct.
As much, that is why only a benchmark is there.
That's correct.
It should be there. If you look at this, so far in the last years, Bar Council has not done anything by which we should discuss them either. So why not give a full
And your
play?
lawsuits are fine tuning the syllabi anyway.
In any case, we are monitoring those issues in the other matters.
Honorable Sinha is looking into it, not which.
And if he's a
Yes, track.
meticulous man, he will look into it.
Lordship says, gone to the Singapore model and other things. He's telling
It's any judge of this would be have an element of passion to ensure
Yes.
that the assistance rendered to judges. Ultimately, that's the only objective of it. It's not that we want to disqualify somebody, but we should not be left. If he's fumbling, then sometimes we can be left fumbling over issues.
I think that will serve the, and that's why it's part of administration of justice. We raise it to 77, 78, dealing with establishment of courts, people who practice there. So, I think this, I will rephrase my page 40, para 88 in my second note. Rephrase it in the light of my discussion, I enriched. Rephrase it. So, Your Lordship may, at the moment, give back.
Part of this.
No, my lord. With that, the answers, my lord, 1 and 2, 3 will be rephrased, my lord, saying that there is power. With Sudhir, my lord, the Indian Council also, Sudhir relied on Indian Council, that age bar of 45, where this honorable court added one line saying that under 49, 1AH, you can only mention the people entitled, not those who are debarred. Kindly have a look at Indian Council, my lord, because Indian Council was relied on Sudhir. So both have to go.
Yes.
The citizen, the Bar Council's compilation, Mr. Artendu's compilation, page 15. And I'll show where Sudhir relies on it.
Compilation.
Page 15 at 24, my lord, and Sudhir relies on this. That is the Attorney General's compilation.
Now you're referring to which one page?
Page 24 of the compilation, a case called Indian Council, where the ceiling of 45 years for enrollment was called into question and struck down.
Yes.
If your lordship will not come to 23 bottom.
Yeah.
The newly added rule seeks to bar the entry of persons who have completed the age of 45 years on the date of application for enrollment as an advocate for being enrolled as such by the State Bar Council concerned. While section
Page
40,
23 or
sorry, from 24 I went to 23 for completion.
Paragraph
of
8.
the compilation. Para 8. In the Bar Council's compilation.
Yes.
The para beginning, the newly added rule. Bottom middle.
Yes.
Yes. The newly added rules bar the age of persons who have completed the age of 45 on the date of application for enrollment as an advocate from being enrolled as such by the State Bar Council concerned. While section 24 of the Act prescribes the minimum age for enrollment as 21 years complete, there is no provision in the Act which can be said to prescribe the maximum age for entry into profession. Since the Act is silent on this point, the Bar Council of India was required to resort to the rule-making power. The rules made by the Bar Council of India under Section 49(1) are in 7 parts, each part having its own chapter. Part 6 is entitled to Rules Governing Advocates, and the said part has 3 chapters. Chapter 1 sets out the restrictions on senior advocates relatable to 16(3) and 49(1)(g). Chapter 2 lays down the standards of professional conduct and etiquette relatable to Section 49(1)(c), read with proviso thereto. And Chapter 3 deals with conditions for right to practice and is stated to be made in excess of powers under Clause AH of subsection 1 of 49. That clause reads as under: conditions subject to which an advocate shall have the right to practice and the circumstance under which a person shall be deemed to practice as an advocate in a court. In the plain language of the said clause, it seems clear to us that under the said provision, the Bar Council can lay down the conditions subject to which an advocate shall have the right to practice. These conditions which the Bar Council of India can lay down are applicable to an advocate, that is, a person who has already been enrolled as an advocate by the State Bar Council concerned. Conditions which can be prescribed must apply to the post-enrollment stage, since they are expected to relate to the right to practice. They can therefore not operate at the pre-enrollment stage. By the impugn rule, the entry of those who have completed 45 years of the date of application for enrollment is sought to be barred. The rule clearly operates at the pre-enrollment stage and cannot therefore receive the shelter of Clause AH of 49(1) of the Act. Under the said clause, conditions applicable to an advocate touching his right to practice can be laid down. And if laid down, he must exercise his right subject to those conditions. But the language of the said clause does not permit laying down of conditions for entry into the profession. We have therefore no hesitation in coming to the conclusion that Clause AH of 49(1) of the Act does not empower the Bar Council of India to frame rules barring persons who have completed 45 years of age from enrollment as an advocate. Impugn rule is therefore ultra vires said provision. Can the rule be saved under any other provision of the Act? As stated earlier, the Act 24(1)(b) provides that the person who seeks enrollment as an advocate must have completed the age of 21 years. Nowhere does the Act provide the maximum age beyond which a person shall not be entitled to enrollment as an advocate, nor does the Act make any specific provision empowering the Bar Council of India to frame such a rule. Reliance is, however, placed in Clause AG of 49(1), which reads as under: AG, the class or category of persons entitled to be enrolled as advocates. Can persons who have completed 40 years of age be said to constitute a class or category to entitle the Bar Council of India to debar them from being enrolled as advocates? Rule 49(1) empowers the Bar Council of India to make rules for discharging its functions under the Act, in particular those enumerated in A to J thereof. None of the functions under the Act, Section 7, specifically provides for laying down such a condition debarring persons of a certain age group from enrollment as advocate. Clause read upon is couched in positive terms, namely it says the rules may prescribe the class or category who may be admitted to the legal profession. Therefore, under this clause, the class or category of persons entitled to be enrolled as advocate may be prescribed. The rule can therefore specify the class or category of persons entitled to be enrolled, but the rule gives no indication that it can debar persons belonging to a certain age group from being enrolled. So it is correlative, Millard. It's only the positive part. Once you say only these people can do, the others automatically the others can't do. But kindly see, Millard, how Sudhi relied on this.
Okay.
So this also, Millard, have to be the larger number. You are kindly see Sudhir in the Learned Attorney General's compilation. Just one para. Learned Attorney General's judgment compilation. Sudhir is here, but all right. Millard, we will refer here only. Page 50 of the same compilation.
We mark that. The marks.
So, that is better always. Page 77 in the Learned Attorney General's compilation.
Yeah.
Kindly come to Millard 77, right in column, plus item F. However, line about 10 from bottom.
Yes.
My lord.
Yes, carry on.
However, the question is whether Section 49(1) AH confers such a power on the Bar Council of India. So far as this question is concerned, it has stood answered against the respondent Bar Council by a 3-judge bench judgment of this Honorable Court reported in Indian Council of Legal Aid and Advice. Chief Justice Amely, speaking for the 3-judge bench, considered in the said decision the question whether the Bar Council of India could frame a rule restricting the enrollment of advocate to the state roll to only those who had not completed 45 years of age. Holding such rule to be ultra vires the powers of the Bar Council of India under the Act, it was held that such a rule could not be sustained under 49(1) AH, as the said provision dealt with the situation after the enrollment and could not take in its sweep any situation prior to the enrollment. The Law Learned Council for the Respondent Bar Council of India tried to salvage the situation by submitting that the said decision was per incurium on the ground that 24(3)D was not noticed. We have already held that 24(3)D is the provision which permits the Bar Council of India by exercise of the rulemaking power to make an otherwise ineligible person eligible for enrollment and does not act in the reverse direction to make an otherwise eligible person ineligible. Once the conclusion is reached, 24(3)D becomes totally irrelevant for deciding the question whether the rule impugned before the three judge in that case could have been sustained by the Bar Council of India by taking resort to 24(3)D. Non-consideration of such irrelevant provision therefore cannot make the ratio of the decision in the opposite case per incurium. Second ground on which so and so, etc. Yes. And again, we note Indian Council mentioned in 79.
10th line from top. Huh?
10 line from top, it is difficult to appreciate how the opposite decision of the Constitutional Bench and Lily Thomas for sustaining the rulemaking power of the Bar Council of India, the extra provision of 724(3)D read with 49(h) would be only relevant provisions which were considered by this court in a three-judge bench. Ratio the Constitutional Bench rendered in connection with an entirely different question posed for decision in the light. So and so scheme dealing with the rulemaking power of the Supreme Court under 145 cannot be said to be laying down anything contrary. So, and then below again at 27, consequently such a rule cannot be sustained, line about 5. Under the opposite provision as clearly ruled by three-judge bench judgment of this court in Indian Council. Even that apart, 49(a) clearly shows that the provision enables Bar Council to lay down conditions to which an advocate who has already got enrolled and a right to practice. Right to practice advocate is duly enrolled under the Act is a full-fledged right to practice, which as noted earlier would include not only seeking adjournment but also to plead and argue for the court for whom he appears. Thus, any truncating of very right to practice itself in exercise of rulemaking power under AH by creating a new clause of trainee advocate cannot be sustained by the said provision. All that the said provision enables the Bar Council to do is to frame rules under the said provision which may impose conditions subject to which an enrolled advocate can carry on his full-fledged practice advocate. In this connection, it is profitable to look at the very rules earlier enacted by the Bar Council of India under 49(a). They are found in Part 6. Then they go to the training rules. Since Indian Council is relied on in Sudhir in a manner as to restrict the power, considering without the movement response to earlier, this part of Indian Council also will not be wrong. Insofar as it will not is to hold that there cannot be a pre-enrollment or a post-enrollment going by that logic. My respectful submission is that the Lordship declares Sudhir Milord as not having laid down the correct law. And Milord, of course, the Lordship will address all the issues, concerns which have now happened, and the fact that the post-enrollment exam is working, which is being fine-tuned in the other matter. So that in the larger interest of administration, Milord, we have mentioned in the Milord, in my note, your Lordship will find Satish Kumar Sharma's case, Milord, that recognizes the overarching power. And so does, Milord, the Pratap Chandra Mehta's case, the electoral roll case, Milord. I don't want to, Milord, multiply that. Lordship only flag 84, page 84 of my note, para 84, and Satish Chandra Sharma, Milord, repeatedly referred to.
Please.
In my note, Milord,
Yes.
page 33, Satish Chandra Sharma's case on the scope of 49, and Milord, Bar Council's power, page 37, para 84, Pratap Chandra Mehta's case. Milord, the supplementary note, Milord, this 5, 6 aspects we will address. And I'll rephrase para 88. Very grateful for the opportunity.
Thank you.
Thank you.
Thank you, this.
Two things, Lord, the section 6 and 7. 6 prescribes, Lord, the functions of the State Bar Council. 7, Lord, already been discussed, Lord, so many times. Now, my Lord will see, Lord, there are two things. Definition. Section 2. Lord, the Act defines Section 2D, Bar Council means Bar Council constituted under this Act. And then E, Bar Council of India means, Lord, so Bar Council and Bar Council of India are two different things. Lord, I'm drawing my Lord's kind attention to these two definition clause. Lord, now coming to section 415.
Giri, you can come back at 2 o'clock. I think it will take that much of time.
Yes.
There are 2, 3 other lawyers who want to have a say.
I wanted to just mention it to your lordships, but the master may also kindly help me, because the compilation of judgments and compilation of notes and other things, it is in 2 volumes. But soft copy, I'll send it to the court master. The hard copies also, at least 3 of them, I'll hand it over by one. It was difficult, my lord, because some materials were coming in only late last week. Otherwise, I would have filed the compilation. I asked an associate of mine, also an advocate of Turkey, he said, "Bhagat, my lord,
That's fine.
grateful."
So, Lord, section 15, that is the power of State Bar Council to make rules. Now, this power, if my Lord kindly have a look at. The Bar Council may make rules to carry out the purpose of this chapter. This chapter, in particular and without prejudice to the generality of the foregoing power, and the rules may provide for the election of the members of Bar Council by secret ballot, including so and so. Then the manner of election of chairman, vice chairman, the manner in which and the authority by which the doubts, disputes as to validity, the filing of casual vacancy, power and duties of chairman, constitution of one or more funds, organization of legal aid and advice, the summoning and holding of meeting of Bar Council, the constitution and function of any committee of Bar Council, summoning and holding meeting of the conduct business, qualification and condition of service of the secretary, maintenance of the books of accounts, the appointment of auditors, the management and investment of funds of Bar Council, and then no rules made under this section by State Bar Council shall have effect unless they have been approved by the Bar Council of India. Lord, these are the rule-making powers of the State Bar Council. It doesn't talk of, Lord, the
Enrollment.
enrollment or all that. Now, section 49, my Lord has seen, it is specifically giving power, Lord, to the Bar Council of India. Coming to section 24, my Lord will see this is the qualification prescribed for being an advocate. This is simply a qualification. I am a graduate, I am qualified to be an IAS. But simply because I am a graduate, I cannot be a collector or an IAS. I'll have to go through the UPSC exam, the preliminary, mains and interview, all that. That is not the condition. The section is very much clear. Subject to the provisions of this Act and the rules made thereunder, a person shall be qualified to be admitted as an advocate. This is simple qualification. How you will be entitled to practice and how you will be enrolled as an advocate, that is the power given to the Bar Council of India under section 49, under the rule-making power. The power of supervision, the power of control, the power to issue directions to all the state bar councils, that is very much already has been discussed, the section 7 and section 48B. So, my lord, the power is very much there. My lord, these sections coming to 49 AG, my lord will see, supposing, my lord, a man is law graduate, he has got the LLB degree, but he is an accused, he is charge seated in hundreds of cases. The Bar Council of India can say that such person may be a citizen of India, may be having the law degree, may be fulfilling the other conditions prescribed under section 24 of the Act, but such persons should not be admitted as an advocate. Lord, that is why, Lord, this section AG, 49 AG has been given. And so far, Lord, AH is concerned, my lords are very much, Lord, clear on the point that who will be entitled to practice even after getting enrolled as an advocate. The certificate of practice, that is completely another thing. And that power we get from, Lord, this AH. Lord, that's the simple submission for my lords.
Anybody else from the bar council?
Lord, you
Something?
Written submission.
Lord, the Advocates Act has given power to the Bar Council of India of control over the state bar councils, Lord, in every chapter. As Mr. Mishra has said, because if your lordships have all the chapters, your lordship said in 24 the prescribed condition can be given only by the state bar council. Because even in that chapter, section 28(3), those rules have to be approved by the Bar Council of India. So therefore, my lord, the functions of the Bar Council of India under 7(1)(g), which gives the supervision and control, is an absolute control. It cannot be said every function in every chapter of the state bar councils. If your lordships have the Advocates Act, the second chapter is the bar councils, wherein the functions have been mentioned, lords. Now the functions of the state bar council is section 6. Functions of the Bar Council of India is section 7, lords. Now in this chapter, lords, and as my learned senior has said that the term control in the Nagpur city matter, lords, that the term control is of a very wide connotation and amplitude and includes a large variety of powers which are incidental and consequential to achieve the power vested in the authority concerned. So if your lordships have section 6, the functions of the state bar council, it is to admit the person as advocates on the roll. My function as Bar Council of India is G, my lords, to exercise general supervision and control. Now this control is with me in every chapter. Chapter 2, section, my lords may see, section 15. No rules made under this section by a state bar council shall have effect unless they have been approved by the Bar Council of India. This is section 15(3), my lords. Then, my lords, just thereafter is chapter 3, admission and enrollment of advocates. Now, my lords, herein, section 24 has given power under 24E to the state bar council to make conditions. Any rule in this chapter, my lords, is at page section 28.
No, just 1 minute.
Yes, my lord.
See, 24 gives the right of persons to be admitted on the state rolls.
Yes, my lords.
The rolls are state rolls.
Yes, my lords.
Not the central bar council.
Yes, my lords.
Now, thereafter, if you turn to section 28,
Yes, my lords.
now the state bar council may make rules for the purpose of this chapter.
Yes, my lords.
So specific powers for making rules
Yes.
is given under 28. We need
Yes.
not refer to section 16 then.
Looks entire chapter.
One minute. We need not refer to chapter 16, section 16 then. With regard to the rule making power under the other chapter 2. So specific rule making power as far as chapter 3 is conferred is upon them. You write to that extent that no rules are made under this chapter shall be given effect to unless
Correct.
they have been approved by the Bar Council.
Correct, my lords.
But after the rules are made, can the Bar Council of India force them to change the rules?
My lords, under 48B, it is me. 48B1, it is the Bar Council of India, which can prescribe and it shall be complied by the state bar council. Lords, may kindly see.
Similar provision is there.
ये तो सिर्फ वही है कि
वही।
rules-
Yes,
Whatever reasons, what. I cannot.
The rule
Pass
15
approval
which
is
has been
given.
said.
100 days for there, there's
and
no right to.
Sub rule
say on
there
that.
too. Rule 15 for the purpose of this chapter.
For chapter 2?
Like,
Yes, my
now
lord.
come to chapter 3
Yes, my lords.
that deal with admission and enrollment of the advocate,
16 onwards, section.
Right.
Yes, my lords.
to which a specific power have been conferred as asked
Yes, my lords.
under section 28
Yes, my lords.
to the state bar.
That to be approved by me under 3.
Yes.
We are not denying of that.
Yes, my lords.
So approval is fine,
Yes, my lords.
but this power is with the state.
Milos.
This is the question.
Now, Milos, here we are talking about the scope and the power of the Bar Council of India vis-a-vis the state bar councils, Milos. Now, what I am trying to demonstrate before your lordships is that the state bar councils, the powers, whatsoever power, the function of the state bar council is to admit on rule. My power is to control the state bar council. So, Milos, controlling the bar council means controlling the functions of the bar council, which ultimately is to admit people on roll. So my power, that needs to be read with
But it is understood as.
yes, ma'am.
the amicus also.
Yes, ma'am. Yes, ma'am.
Referring to various-
Yes, yes, ma'am.
We did in the restrictive manner.
Yes, ma'am. And Milos, for the reason that every
The
chapter,
difficulty in that argument is when there is a power to make rules given to the state bar council. and a
Specific power.
Specific power.
Yes.
Then the principle of exclusion, will it not apply?
Milos, therein, Milos, for example, if I make a rule and I send it to all the state bar council that any person who has cleared an exam after his law graduation shall be allowed or be admitted on the rolls, can the state bar council say no? Because I have the power under 48B1 Milos. I can give direction which shall be complied.
Yeah, in fact.
Lordship, before dwelling into the written submissions, your Lordships, I'll just refer to one particular rule under chapter 3, which they have made. That is what I'm specifically pointing out is unconstitutional, your Lordship. It is violation of there's a violation of Article 14 in that. Lordship, it is chapter 3, conditions for right to practice. This has been made under rules under 49(1)(h). Lordship, I'm referring to rule number 9 of the Bar Council of India rules.
Have you challenged that rule specifically? Have you challenged the validity of that rule specifically in the prayer clause and your grounds?
Your Lordship, yes, Your Lordship, in my writ petition, which I filed in the, so Your Lordship, this is a 2011 petition when, yes, Your Lordship, I have the diagram.
Both you've challenged. Okay.
Lordship, rule number 9, if I may refer.
Yeah.
No advocate enrolled under section 24 of the Advocates Act shall be entitled to practice under chapter 4 of the Advocates Act 1961 unless such advocate successfully passes the All India Bar examination conducted by the Bar Council of India. It is clarified.
Where are you reading?
Lordship, Bar Council of India rules, chapter 3, condition, chapter 3,
Do we have
part
a
6.
copy? Have you annexed it with your compilation?
Your Lordship, this is part of the rules, this.
Our book does not
Our
have.
book is not having it, therefore. we are-
They are in Aegis compilation.
That is Bar Council of India's rules.
Because they are
According
in
to the rules, not to
Bar
the act.
Council of India rules, Your Lordship.
Because by way how the All India Bar examination
Yes,
is
they are
come.
in the.
Your Lordship, in that
compilation.
Yes,
section,
it
we
is.
have extracted.
Just, if you were
It is
present
there in
yesterday's
the
page 739, volume 2 of Aegis.
Yeah.
Yes, age is notebook.
Because that is.
Your Lordship, in my,
This comparison.
the first rule which I have extracted.
Where have you extracted it?
Your Lordship, on page number 5 of my written submissions, right after factual background, the relevant Bar Council of India rules inserted for the purpose of conducting All India Bar examination.
What is the page number in Aegis compilation?
Is there in his compilation.
Your page 5, you are saying?
Yes, Your Lordship.
739.
Right at the bottom.
Not as yeah.
Clearer.
Relevant Bar Council of India rules.
Yes,
May I read, Your Lordship?
yes.
Rule 9. No advocate enrolled under section 24 of the Advocates Act shall be entitled to practice under chapter 4 of the Advocates Act unless such advocate successfully passes the All India Bar examination conducted by the Bar Council of India. It is clarified that the bar exam shall be mandatory for all law students graduating from the year 2009-10 and enrolled as advocates under the section 24 of the Advocates Act. Lordship, my humble submission here is, let's take an example, Your Lordship, where a person graduates in the year 2007 or 1975.
Yes.
As per Bar Council of India, if that person is getting himself enrolled in 2022, along with a fresh graduate who has just graduated, fresh out of the oven in 2022, the 1975 or 2007 person does not have to give the bar examination. Enrollment on the same date. Application for enrollment on the same date. But it says, because you have graduated in 1975, because you have graduated in 2007, you don't have to give the bar exam.
We could have done that way also. This is the only issue is at some stage the introduction of a bar exam was deemed necessary.
I bow down.
Now that bar exam starts from the whole concept from 2019.
Yes, Your Lordship.
There are sometimes problems which you need to remedy, but you can't do it retrospectively. So, especially what is wrong with this?
Your Lordship, if I may say this. Lordship, why it is violative of Article 14? Because,
You may be misreading that rule line. Read carefully.
yes,
It will apply to all fresh enrollments also.
Your Lordship,
It will apply to all fresh enrollments, even irrespective of the year. Plus those who have taken, who had completed the course in 2009-10. So it means that it will also apply to the law students. Just read it. No advocate will be in.
How do you do it? Somebody who has passed in,
Lordship,
say,
I have the, sorry.
somebody who has passed say in 2005.
No, he is not required to,
You don't let.
You're not giving him, he's not required to.
not required, because it was made prospective, not retrospective.
Just read it carefully.
Lordship, in
Just 1 minute, read it carefully. No advocate shall be enrolled. That is enrolled from the date the rule is enforced.
My lord.
Under section 24 shall be entitled to practice under so and so unless he successfully passes the All India Bar exam conducted by the Bar Council of India.
My lord,
Then comes the clarification portion.
my lord,
Because when was the rule enacted? 30th of April 2010.
My lord.
The clarificatory portion says it is clarified that the bar examination shall be mandatory for all students graduating from so and so year
And onwards,
and onwards. So that means this portion is clarificatory, but as far as enrollment, as far as the main provision is concerned, that will that not stand independent?
What is being put is, suppose somebody has passed the examination, never enrolled with you. He's enrolled, he doesn't have to take the examination. But suppose somebody has passed the examination, did not enroll with you.
no, without enrollment, he can't be.
An advocate.
He cannot be.
I'm saying somebody passed an examination, started doing something else, took up a job, did something else, spent life. And then when ultimately, say at 50 or 55, they say, I want to now enroll. And the period when he's seeking an enrollment is the period of 2013, 14, 15. Let's say the age of 55. Is he supposed to take an examination or not supposed to?
Lord, as per my lord's guideline, we have already made provision for that. But at that time, Lord, the provision was made that those.
Are you taking now? Okay, let me say after the guidelines have been issued, all this.
My lord, my lord.
You are taking the examination.
My
So
lord.
the idea was check and balance even in terms of judgment which said that somebody may come in at 50. See, somebody may come at 50 years of age but must take the bar exam, he is not already in it. That is the position.
My lord.
The challenge does.
Your Lordship, if I may just point out, Your Lordship, I have submitted from the Bar Council website, there are frequently asked questions which have been put. Lordship, I'll read out a particular question which is there, which has been put and answered by the Bar Council.
Appreciate in the other orders passed in the other matters.
Yes, Your Lordship.
Yes, this issue has been taken care of. So even if you say that they were not reading it in a proper manner, they were permitting people to be enrolled as an advocate who had passed 20 years ago the examination without taking the examination. That issue has now been addressed.
Lordship, there are two places in the Bar Council of India rules. Lordship, there are two rules. One is for conditions for right to practice. Then there's another rule which came in 2015 by Bar Council of India, which is the Bar Council of India Certificate and Place of Practice Verification Rules 2015. There, Your Lordship, definitions, they have clearly given under 4D, Certificate of Practice. Lordship, I'll just read out the Certificate of Practice for convenience. Certificate of Practice in relation to an advocate having obtained graduate degree in law before the academic year 2010, enrolled on the rolls of advocate shall mean a certificate of practice issued under Rule 13 and in relation to an advocate graduating in law in academic year 2009 and 10 and thereafter enrolled on or after 12th day of June 2010. Certificate of practice means a certificate of practice issued under the All India Bar Examination rules or under Rule 13 of these rules or the enrollment certificate issued by the Bar Council.
Is the grievance something else then? Is what I've understood your grievance is that somebody who passed the bar exam earlier, never enrolled himself, is not required to take the bar exam.
Yes, Your Lordship.
While people from 2009 and 10
Yes, Your
have to take it.
Yes, Your
This is discriminatory.
Yes, Your Lordship.
Therefore, we are telling you, even if it has happened in the past, the manner of construction, fact today is that as per norms today and followed by the Bar Council, anybody who does not, the right accrues only after enrollment. So everybody has to take an exam today, irrespective of when he graduated. As long as his enrollment is after 2019. Mr. Vishnu, am I?
My lord, my lord, my lord.
Yes, Lordship, as it stands today, the
I'm
rules.
telling you, as it stands is what? You also filed a petition in 2011. See, much water has flowed. Today, the position is it is being made mandatory.
Lordship, the 2015 rules, which was made post that also does not say. And Your Lordship, in this slide, I'll just mention one particular thing, which is because we are going beyond what is stated in letter and spirit here, Your Lordship.
No, spirit is correct.
Yes,
Sir,
sir.
maybe a little defective, but spirit is correct. Spirit is you cannot get into this profession without taking a bar exam.
As of now, Your Lordship, what I'm submitting is
So if
that
you
the
are
rules.
Saying is, please let us be enrolled without taking the bar exam.
No, I'm not saying that, Your Lordship. I'm saying it is violative of Article 14, Your Lordship.
It may be violative of anything. We will not let you enroll as a lawyer without.
I bow down, Your Lordship. I bow down, Your Lordship. Now,
Yes.
yeah, Your Lordship, all I'm saying is in this slide, I'll just refer to what Justice Frankfurter said in Mori versus Dowd case. That courts have the power to destruct, not to reconstruct. And I bow down, Your Lordship, that here,
This court has been constructing and deconstructing for a very long time.
no, I understand. I bow down, Your Lordship.
And first part of Rule 9 is so clear. First part of Rule 9.
Yes.
So there's no difficulty at all that their Article 14 argument will not be attractive.
As both my brothers said, this is Khanna also said, that's an explanation. So if they were wrongly construing an explanation, that has been taken care of in the others. See, we are trying to understand what do you want?
No, I am. Your Lordship, I am against the post-enrollment examination and I will demonstrate that, Your Lordship. I am against the post-enrollment. Pre-enrollment might be still valid, Your Lordship, because it is
Still
not.
valid. Do you want, looking for a question, right?
Yes, Your Lordship.
Do you want an examination? Do you think no examination should take?
Examination should be there.
Okay. Now, so far as examination prior to enrollment is concerned, you are okay with that? You feel there is nothing wrong with that?
There
What's
is
the
nothing wrong with that, and I have a suggestion with regard to that, Your Lordship. I'll just submit that. Your Lordship, Your Lordships were mentioning there are large numbers of advocates enrolling every year and all that. Learned Amicus pointed out, I had the same suggestion. Learned Amicus pointed out we can have the examination in the 5th year. Your Lordship, if I may just submit here, CBSE and ICSE hold examination every year for much more than how many lawyers are getting enrolled every year for 10th and 12th examination. Your Lordship, along with the final semester examination, Your Lordship, I am one of the ones who have given the bar examination. I'm 2010 graduate given the examination. Your Lordship, that's where I'm saying if I would have had the opportunity to give it in the 5th year with all the other examination.
For the bar, we are not prohibiting it. It's for the bar council to consider. We
No, I
date that they must do so.
Your Lordship, that will stop the wastage of the time of the person who has
Maybe it
graduated.
can be what you are saying is actually a suggestion to the bar council.
Yes, Your
Council will explore it.
I bow down, Your Lordship. Your Lordship, if I may just point out certain things with regard to the post-enrollment examination,
Yes.
why there is a problem in that particular thing, Your Lordship. Your Lordship, I'll just refer to my particular written submission. There's just giving what were the questions which were raised, which were referred to this Constitution bench, Your Lordship. That was wide and order dated 18 March 2016, Your Lordship. So, Your Lordship, in my humble submission, Your Lordship, that I have annexed as well that particular order.
I've seen that order. So we what is
Your Lordship, the reference is with regard to whether V. Sudhir is correct or not.
correct.
Your Lordship, whether a pre-enrollment examination can be prescribed by the Bar Council of India. In case questions number 1 and 2 are answered in the negative, whether post-enrollment examination can be validly prescribed by the Bar Council in terms of section 49(1)(h). Your Lordship, my humble submission is their powers get derived from 1(8)(g). Your Lordship, not 1(8)(h) because and if they are doing it under 1(h), Your Lordship,
They have the power, na?
1(8)(g) for pre-enrollment.
Yes.
Not under 1(8)(h) they cannot.
That's the debate, whether 49(1)(a)(g), 49(1), they have the power.
Yes, Your Lordship, I bow.
Okay, so that is the source of power is that provision.
Yes,
You
Your
are
Lordship.
saying source of power is not A, source of power is another subsection.
Yes,
It
Your
doesn't
Lordship.
make a difference practically.
Your Lordship,
As long
there,
as the power exists.
Your Lordship, there, it has to be in consonance with the other provisions of the Act. Here, Your Lordship, I am humbly submitting. When we the functions of the Bar Council is one regard to, I'll just broadly point it out. One is with regard to the legal education per se. The other is with regard to the conduct and how the enrollment functioned, everything with regard to the advocates. Now I humbly submit, Your Lordship, let's come to the pre-enrollment stage. If we are holding an exam and if we are holding it after my 5th year, after I have got my degree, then Your Lordship, what happens there? Neither am I an advocate, neither I am in the legal education, Your Lordship. I'm not even a part of the legal education because I have passed out of the law school. I've got a degree in my hand. Section 24 enables me to enroll. But
You are saying you're neither here nor there. Enjoy your degree. Nobody stops you. You can do many things. See, out of practice, you can do many things. That law degree is a supplement or a benefit for many things. It may be for a job, it may be for people do it even for their own businesses sometimes.
I understand.
Equip themselves. So all those things are open for you.
Yes, Your Lordship.
But if you once decide that you are part of this profession, then there are certain norms which come into as a part of this profession. And to control the quality of people entering into the profession, our council must have a full play, because that's what the intent of the Advocates Act is.
What you are suggesting, the Bar Council will be very happy. If they're given right to hold examinations and when you're studying, they'll be the most happy.
Your Lordship,
So at the second and third year of the second and third year law course and fourth, fifth year in the, or third, fourth, fifth year,
that will be the reason why I'm suggesting that practical solution is only because of this.
they'll be very
We
pleased.
will not be wasting our times after graduation. Your Lordship, I mean, for example, we get a placement offer as well, Your Lordship. We get a pre-placement offer in all the law schools.
Understand what you are saying is, in the final year of your law exams, like you can appear for IIT, you can appear
Yes,
for
Your
other
Lordship.
examination. It is subject to clearance of CBSE.
Exactly.
So the bar exam may be held, and the condition may be then subject to your clearing the examination.
Yes.
Suppose unfortunately you don't pass one paper,
Yes, sure.
then even if you have passed the bar exam, you cannot get it.
Exactly, Your Lordship.
Suggestion. It's for them to analyze that suggestion.
I bow down. I bow down. But Your Lordship, I just come to my written submissions with regard to the analysis of section 24, Your Lordship. Your Lordship, and there I have annexed the 1973 deletion, Your Lordship. Your Lordship,
It was that correct or not, that power of deletion was.
that was State Bar Council. I bow down.
We accept that.
Yes, sir.
Now, the intent, if you ask me, would be
Yes, sir.
that the legislature did not want the state bar councils to exercise this power because of a possibility of inconsistent. We don't know, because no rationale is given why it is. Maybe it is because of a strike, as you said, maybe because of some agitation. But the taking away legally only takes away the state bar council's power.
Yes,
It
sir.
doesn't take away bar council of India's power. Is that not correct?
I bow down, Your Lordship. Your Lordship, I just with that particular thing, Your Lordship, with regard to since 1963, Your Lordship, then in 31st January 1974, then again there was a particular State Bar Council power which was taken away. And that I have annexed with the particular, I have annexed the 1961.
How does it affect the power of the bar council of India?
Your Lordship, I am talking about the genesis of the Act per se, Your Lordship. In Act, there were powers given to the Bar Council to do a pre-enrollment examination, or Your Lordship also.
State bar council, again I'm saying,
Yes, sir.
powers of state bar council are taken away, well taken.
Yeah.
Powers of bar council of India, has it been taken away anywhere? Please point out.
No, Your Lordship, the Learned Council of Bar Council of India himself pointed out that all the state bar councils do, and then the Bar Council of India runs their functions. So, Your Lordship, in effect, the
It enrolls, the power is still. In fact, even though I like the issue of, say, the charges being done,
yes, sir.
the purpose was for the bar council itself to consider these issues.
I bow down.
I flagged it because they were raised, and their youngest boy.
Lordship, I have a financial section. I have put a financial section in my particular written submissions. Your Lordship, I'll point out how much we are paying after enrollment. And they say that after enrollment, there's only one fees for enrollment. They charge us 3,500 for everybody for exam. They are earning 42 crores, 44 crores just by holding the bar exam.
Pre-exam will not take place.
No, definitely, Your Lordship, but 3,500.
Again, can the constitutional court say it should be 3,000, not 3,500?
No, I know.
These are ideas why we read something, though it was not strictly something which we had to analyze was. The purpose was clearly to flag these issues
Right.
for bar council to examine, which they say so. Now you are saying something else. Certainly there are issues flagged with the Bar Council of India to consider within that domain.
Definitely.
That purpose certainly, what you say, coming into these issues which you have said in terms of where fine tuning is required. Maybe fine tuning between Bar Council, State Bar Council, Bar Council of India, all that is required.
I bow to Your Lordship. Your Lordship, then I just turn to section 16, Your Lordship.
Yes.
There are two classes of advocates,
Senior and
senior and other advocates. Your Lordship, now, when we are having a post-enrollment examination, there's a third category which is being used, which is enrolled, but which is a non-practicing advocate. Now he's enrolled.
It is to facilitate you people, that's all. That was made to facilitate, otherwise people would have been twiddling their thumb for this long period of time.
Lordship, if I may
In fact,
just,
that has been our concern only. The caveats we have in our mind about a pre-bar exam I'm not about the constitutionality of it,
Yes.
but as to the consequences of it. Please understand. So therefore, when this was given, an exam had to be held, they did it to facilitate. In fine tuning that, in the other matter, we said, okay, keep one, because what was happening is some people are not clearing it in 2 years.
Yes.
They're still continuing. So we passed various orders from time to time in that matter. And we are continuing to monitor it and propose to take it to the logical conclusion to streamline the process.
I have.
Anything else?
Yeah, Your Lordship, I have just 3 more submissions, Your Lordship. Your Lordship, I can
Take it up.
grateful, Your Lordship.
Should explain my
24 and 30 specifically talks about two classes of advocates, Your Lordship. One is advocate, one is senior advocate. It does not talk about the third category of advocate, which is advocate but a non-practicing advocate. Now, Your Lordship, in terms of that, Your Lordship, there,
I
yes, sir.
told you. The structuring, yes, if you go by the letter of the law,
Yes, sir.
maybe right. But then it's a structuring for the benefit of the legal fraternity.
Aye.
Should we take a view which will disrupt it? Please understand this. Should we leave them in a hiatus, not to be able to do anything? If at all, it is facilitative in character. What is sought to be done is facilitative in character.
Your Lordship, I bow down. Your Lordship, what I'm trying to say here is that Your Lordship, unfettered powers to BCI by saying you hold post or pre, it's up to you. That would be in my humble
Like a
submission.
disciplinary controlling authority, if tomorrow action is to be taken against you, they will take against
No,
you.
no, it's absolute. I bow down, Your Lordship.
So therefore, yes, they should be held in, but now over a period of time,
Yes, sir.
they have established a regime of a post examination.
Yes, sir.
It is working. Pre could have also worked. Pre has its own complication. Post has its own complication. So far as post complications are concerned, in the other matter, which if I am presiding, Bar Council there, Vishwanathan is assisting.
Yes, sir.
Suggestions continuously being made and implemented. So we are actually, not our role, but we are monitoring to see that there is a translation of idea. And to the credit of the Bar Council, they have fully cooperated in implementing it. Committees have been found, other things of strengthening the system have been made. Sometimes all solutions cannot be found in one matter.
I understand.
That is the matter dealing with another aspect. Here we are dealing with a constitutional aspect. Please look at the scenario. We have to also, if we were dealing with some very, very technical constitutional issue, we'll deal with it. Here, we're dealing with the act, dealing with the members of the bar. We are also concerned, the questions we posed in the morning, but concerning the lawyers, they don't concern us.
Yeah.
How will it be structured? How will it, they're not strictly arising from the constitution framework. The idea was to flag issues so that the Bar Council also bestows consideration on issues like the quantum being covered by the State Bar Council and others. Our endeavor is to facilitate the whole thing. Please don't take a very, you have done good job, you prepared it well, you've given a very nice synopsis. Only thing is the page number is a little dim for us to
I'm
read.
really sorry.
No, no, other than that, it's a very nice.
In order to improve the quality of the page,
Yes.
we
you-
lack somewhere.
You've done some good homework for producing the material. Let's work out in a situation which will facilitate
Your Lordship,
our ultimate
only-
objective, which is to see that the Bar Council, the Bar exam caters towards producing and checking better lawyers in terms of if your abilities are not up to the mark,
I-
you must improve your skills before you come into the bar.
Definitely.
That's the objective.
Your Lordship, Your Lordship, I'm part of the bar. We have nothing against the Bar Council. We have nothing. Your Lordship, what I'm pointing out is with regard to the post-enrollment, the reason why being, Your Lordship, because this particular bar exam, Your Lordship, I would refer to him as the father of the bar exam, Mr. Gopal Subramanian, for the reason, because he was the ex-officio chairman in
He
2010.
did some wonderful work on it.
Yes, sir. He was the ex-officio chairman, and Your Lordship, that was the only time after Mr. Seetalwad that an ex-officio chairman, the Solicitor General, was appointed as the Bar Council of India chairman. And there was a period, that was the only time period, Your Lordship, of around 1 year, when Mr. Gopal Subramanian said that no, there has to be a bar exam. Your Lordship, now Your Lordship, the first matter which you are dealing with here, there was an order passed, Your Lordship, by Justice Dalveer Bhandari's bench. Your Lordship, I've annexed that. That is very relevant. How all this came into picture, how the bar exam came into picture. That was a suggestion made. So, Your Lordship,
So
what kind of bar exam was suggested at the very first stage?
See, everything evolves over a period of time.
Definitely.
No, nothing stagnant in the world.
No,
The stagnation means sufferance.
definitely.
You have to move ahead. So some experiences,
Definitely.
some thought processes, good beginning made, improvements made over a period of time. Good idea, nobody doubts that.
Definitely.
So we consider all this, we'll see how to structure it. We are really concerned with some, you have some apprehension that the Bar Council should not get some unfettered power. We'll
No,
see what
Your
it
Lordship, there are reasons behind that because it will become so unreasonable, Your Lordship. I'll give you one example, Your Lordship. Your Lordships were talking about seniority at that time. I was just preparing on that. Your Lordship, section 21 says on the date of which the person enrolls, the seniority is counted from that day. Your Lordship talks about a post-enrollment examination. Your Lordship, you give a person, an advocate, the right, the Bar Council of India rule says that the person can appear any number of times for the Bar Council examination. N number of times. There's no bar, there's no limit of the examination which you are holding. So what happens here is, if I am enrolled in 2010, your lordship, as a lawyer, I give the bar exam in 2010 itself. I clear the bar exam, my seniority starts from the day when I'm enrolled. Another person who's enrolled with me on the very same date in 2010 doesn't clear the exam in the first round,
It happens in the second round.
or third round, or fourth round.
No, it's not unlimited. The person has
No,
to
no,
clear
four,
it in 2 years.
four, your lordship.
2 years.
2 years.
4 years, 4 times.
4 times, maybe suppose they hold the exam 3 times a year, it will be 6 times.
Yes, sure.
But you get a window of 2 years to clear the exam.
Yes, sure.
Correct. That's it. Similarly, when we flagged the issue of seniority, it was also arising that even if you do a post exam, so there is no perfect world. Okay, so in an imperfect world, we have to see how to reduce the imperfections.
I bow down.
Otherwise, the simplest thing is we can simply decide the constitutionality and go over with it.
I
But why we have flagged these issues is we want the Bar Council also apply its mind to these issues. Somewhere in the other matter, once we have passed here, it will come up before a bench of us.
Yes.
There they would get back on the issues we have flagged. We can monitor those issues.
I understand. I understand that, Your Lordship. Lordship, I'll just come to page 106 for a
Yes.
moment. Your Lordship, that is a clear page number, thankfully. It's on the top.
Absolutely clear, yes.
Top right.
Yeah.
Lordship, this was on 29 June 2009, Your Lordship, where this particular issue was the first time raised, which is the lead matter in this case, Your Lordship.
Yes.
This petition filed by the Bar Council of India raises very serious questions regarding affiliation and recognition of law colleges by the Bar Council of India. It is a matter of common knowledge that before granting affiliation, proper exercise is not carried out. No serious efforts have been made by the concerned authority to learn about the infrastructure, library, faculty before granting
This has all
affiliation.
happened. This has all been monitored in the other matter.
Yes,
What
yes.
I'm repeatedly telling you again.
I bow down, Your Lordship. What I'm
What's
trying
the
to
purpose
say,
of reading this order?
what I'm trying to get from here, Your Lordship, is then the report, Your Lordship, if the job of the Bar Council at the first part, which is the legal education aspect, is carried out properly, then there will never be a need for a bar examination. Your Lordship, if there are colleges which are run in a proper manner,
If
facilitating.
there is no pollution in the world, nobody will have coffee. It's not similar kind of an example. If there was everything fine with the education, those people would not have passed. You have 1,700 law schools. Can you shut down 1,000 law schools? And please understand the various other ramifications. Some people like you may be here practicing. There are people practicing in Mufassil towns. It requires an expertise of a particular level and enough number of lawyers who are willing to practice there. Will you go and practice in a district in a state? You will not. Somebody has to practice there. Na? He has to also provide relief to those people. Therefore, the degree of proficiencies will vary. You provide a minimum benchmark of proficiency. You are not, therefore, we are not saying, it's not that the person who gets 80 marks practices in city, person who practices 70 marks practices there. It's a benchmark and you choose it. So there may be people who may not be, who have basic proficiency,
Yes.
may not be that great a lawyer, but choose out of their own option to practice at the district and Mufassil levels. If you do a good job of providing legal assistance to them, somebody has to provide legal assistance to them.
Your Lordship, just one point.
Yes.
Page 168 of my written submissions, Your Lordship. Why the whole post enrollment is, Your Lordship, this is the first time when the bar exam question came into picture, and these are the recommendations of this committee headed by Mr. Gopal Subramaniam, along with the Bar Council of India chairman at that time, and also Mr. M.N. Krishnamani. 168 is a bar examination should be introduced for the purpose of admitting law graduates to the bar. As discussed, Supra, the introduction of a bar examination would ensure maintenance of standards in the legal profession, as well as standardization and constant innovation in the standards of curriculum teaching methodology. The committee is therefore of the opinion that qualifying a bar examination should be a requirement prior to the admission to the bar by all the state bar councils across the country.
That's the recommendation. Correct.
Yes, Your Lordship. Your Lordship, then specifically what I'm talking about, Your Lordship.
Next slide.
It said introduced by introduction into the Advocates Act.
Yes, sir. amendments.
Now you are wanting legislative amendments to bring it.
Yes,
We'll do a construction of the act as it exists today. We can't do legislative enactments.
I am.
Not within our domain. If nothing has happened and this report has come, which is the year of the report?
Yeah, this is 2009 itself.
So 13 years has legislative enactment come. Persuade the parliament. Thank you.
Grateful, Your Lordship. Very grateful for your patience.
Thank you. Yes. Yes. What is your suggestion, please tell us?
My lords, I am appearing in the writ petition number 25 of 2021.
Yes.
In the second matter,
Yes, please.
the petitioner is a law graduate
Yes.
and he is from Mumbai High Court.
Maybe for me, come to the point.
Yes, my lord. This is the main point, my lord. So he is not able to pursue the practice.
Why is he not able to pursue? He is not able to clear the exam.
Because of my lord's COVID time, there was some problem. Now it is extended. But that is not my case. My case is, my lord, I just, yes, my lord.
This is not
Well,
a
my-
difficult exam. In fact, it is too simple an exam. That's the problem with this exam.
That is our trouble.
My suggestion is this, my lord.
If somebody is not able to make it, either he needs to strengthen his exam taking ability. Some people get maybe good, but get sometimes very psyched with exams processes.
Yes.
Or possibly he needs to fine tune his skills, take the examination and academic professionals. I'm sure you will help him.
Definitely, my lord, first day also I indicated it and my
No,
lord.
I'm saying you will help that person.
Yes,
Nobody
This is the way, my lord, that will help me.
No, no, you will help him how to take the
Yes,
exam.
my lord. My lord, my point is this, my lord. I will keep in my mind, my lord, that also. And my lord, what is my submission is this.
Yes.
Till today, from 1960 onwards,
Yes.
study reports, audits, judgments, nowhere saying about the post-enrollment exam.
It is talking about pre-enrollment exam?
Yes, we are supporting that.
No, no. Which of these talking about pre-enrollment exam? How many law schools are there of the countries which you take example of?
My lord, why I am saying this? Because today, my lord, even constitution, irrespective of this case.
Yes.
So we are trying to make a suggestion or some mechanism to be implemented, which is according to us as per 1961 Act, Section 21 4D,
Yes.
24 1D.
Yes.
And my lord, for easy reference, my lord may come to the last page of my chart.
Yes.
That is in two color, blue color, then red color. It's for an easy reference, my lord.
Yes.
First column, my lord. First of all, section 24, that is for the easy understanding. Persons who may be admitted as advocates on state road. 1D, my lords are well aware. I don't want to repeat. Then, my lords, section 28. These have been gone, was going and coming back because of repeated acts. The first column, my lords, before 61, what was happening?
Yes.
Bombay and Calcutta High Court, attorneys and law clerks and exam, etc. Well, 61 onwards, according to me, it's very serious. Respondent number, when I enacted the Advocates Act 1961, effective, my lords, in blue color, that blue color area, effect, which is I am supporting. So, effect the act.
When you talk about 61 Act at that time, 61 to 70, the pre-enrollment exam was being held by whom?
Free and by bar councils. I got my lord question. We are not objecting, or we are not saying
I'm just.
state bar council. That is the first two, section 24.
Exactly the distinction. That when the statute was amended, it was in a way to take away the powers of holding a state bar exams. Okay. That may be good. There would be, today we are talking about cute exam. Why? What to bring uniform. Maybe at that time it was thought there was too lack of uniformity. What was being done. How people were aggrieved by whatever. The legislature, in its wisdom, thought it must go its way. They took away the power of the bar council.
Well, my answer is very clear, my lords.
Yes.
See, my lords, then if my lords, about this, what is this chart?
Yes.
2001-15,
Yes.
that's last column. After 61 remained in force, effect, the act prescribed
pre-enrollment training and bar exams. Same time, respondent number 2 arbitrarily introduced AIB rules by with the post exam, a post enrollment exam. My lords, can this be done without following the act which is in force with the 2001 Act? That is what issued by them. That is what I challenge.
We do very simple. State power was abolished. Question is whether the Bar Council of India still has the power of it. Correct? To hold an exam once a person is enrolled. That is the question. Pre-enrollment you also hold. We have discussed at length here in your witness group. Problems exist in both scenarios. Pre-enrollment also has some scenarios. Post-enrollment has also some scenarios. Post-enrollment scenario as it exists today, we are endeavoring to fine-tune it in some way. Bar Council is also attending. Question is whether pre-enrollment can also be done. Yes, I don't think there is any difference of view that pre-enrollment exam can be done. Whether post-enrollment exam monitored as it is by the Supreme Court, would I not be exam? The only thing.
My lords, I have a humble suggestion in that case, my lords.
Yeah.
My lords, saying whether it can be post or pre. My lords, if it is supposed, my lord decide in that way, that post, because whatever your lordship's decision, it is the law of the land.
We don't know. We may even leave
Yes,
it to
my
the
lord.
council to, we will check the validity of a system whereby whether a post-enrollment exam is feasible or not. Suppose we say post-enrollment is not feasible, then they can hold a pre-enrollment, we'll go back. If we come to the conclusion that Sudhir doesn't hold good law.
My lord, exactly that is my.
No, please, we have understood it.
No, my lord, sir, a little more, my lord. Exactly that is what my grievance. I came before my lord's court by way of this writ petition. My writ petition prayers are at page 17. It is challenged AB exam rules. My lord, sir, then suppose post enrollment exam for the time being, my lord, it is allowed or they are going to conduct, or they are having the power 49AH. We are not objecting that. Bar Council of India is part and parcel of us. We are not saying that. But, my lords, after having or after enrollment, as my lord Justice managed to observe, section 2(1), section 30, I completed all the procedure. You have taken money from me. I am from a poor family. And I somehow managed money and enrolled. Now you are saying that you don't have any right.
I'm saying I will not clear the exam, but I will practice.
No, my lords. No, that is, my lords may kindly see the writ petition. What I am saying is, my lord.
This is the effect is this only. Somebody for bad indifferent reason doesn't clear the exam, then he says scrap everything because I'm not able to clear.
No, that's not my.
I'm sorry.
My lords, kindly see my writ petition. What I am saying, pre-enrollment exam, there should have a mechanism. I'm fully with that.
If you can't clear a post enrollment exam, how would you clear a pre-enrollment exam? Is the difficulty level any less of that exam?
My lord.
It's a question of process or the statutory ability to carry it out. But difficulty level is not going to decrease, it's going to increase in terms of guidelines by us.
Well, my great.
So what will happen is now, you want somewhere or the other, you should get it. Not possible.
My lord, my respectful submission kindly.
But we'll examine what your suggestion. Yes.
Yes, you. And my lord, from my written submission, one more point, my lord.
Yes.
Only one more.
Last one. Yes.
But the subject to one can, sorry, subject to an order of observation, if my lords go through this, because of, I gone through some.
Why did you not go through it? You have given ideas from
Because of my lords, because of four countries, 4-5 countries, they already conducting page 1. They are saying that it's a prerequisite. And all the study reports, orders, judgments saying that prerequisite. Parliamentary committee report is
Have
prerequisite.
you also specified how many lawyers practice in these countries?
My lords,
Asking you. Thank you.
that they have some mechanism, my lords. My lords, may kindly go through.
Thank you. Where are you for?
My lordship, I am for
I asked before line 2 are left. 2 people stood up saying they have to argue.
My lordship, in fact, before I could come, in fact, because Mr. Karthik actually started saying he started arguing, so that's the reason I couldn't mention it.
See, we have to limit some time, right? We spent.
My lordship, I would not take more than say 3 to 5 minutes. Your Lordship.
Okay, tell us what you want to.
My lordship,
We have not listened till now.
Please, Your Lordship, let me not repeat. In fact, the learned Amicus has covered actually most of the points that
Thank you.
I would want to argue, Your Lordship. But let me start off with saying that I'm not averse to as far as the pre-examination is concerned. Now, if you have to actually trace the very genesis as to why this issue cropped up, was because looking into, let's say, the facilities of the college, where okay, a 3-member committee was set up, where Mr. Gopal Subramanian, the chairman of the Bar Council, and the president of Supreme Court Bar Association. Bar Association. Now the report that's been submitted by that committee relied upon the 184th Law Commission report, which had made a detailed study, a comparative study of UK, US, Singapore, which actually which suggested that okay, there's a requirement for a pre-enrollment examination. Now, on the basis of that recommendation that is there, the same thing was actually followed in the report also. If your lordships were to see the conclusion of the report, which provides for a pre-enrollment examination itself, your lordships. My lordships, if your lordships were to have
report has suggested pre-enrollment.
Please, your lordship. The reason as to why the pre-enrollment could not have taken place is because of V. Sudhir, your lordships, because the embargo that was created by V. Sudhir.
So if we remove the embargo of Sudhir, then what happens?
My lordship, in fact, the easier way out would be reading section 49(1) AG.
Every individual cannot see the easier way out. If we say Sudhir does not follow the law, then pre-enrollment is possible, correct?
Please, your lordship.
Question is whether post-enrollment is prohibited. Some of them have argued.
It would be prohibited. My summation would be that it would be permitted.
That has already been argued. If you
My lordship, it would be violative of section 30, your lordships. In fact, under delegated legislation, okay, there cannot delegated.
Next.
My lordships, my lordships may have section 49(1) AG.
I'm saying if you have something new, please add. Nothing new and whatever has been urged, then repeating it by 3 councils will not strengthen it further.
I would only want to
reduce the efficacy of it either way.
I would only cement my argument saying that I'm in actual, in consensus as far as the pre-enrollment is concerned.
Everybody here is.
My lordships, in fact, the easier way without an amendment would be that if your lordships were to actually read section 49(1) AG, which can be read into section 24(1), your lordships, where the amendment also will not be required. My argument is that my lordships may have a section.
No, for pre or post, you are saying now.
Pre, your lordships.
Pre, so there is no difficulty.
In fact, there's no amendment also that be required by the legislature, your lordships.
The issue is in a post case, some issue arose which Mr. Vishwanathan addressed. Then he slightly modulated his arguments in view of the debate which took place in the court. That's all.
Please, your lordship. My lordships may have a look at section 30.
Okay, what did Mr. Vishwanathan say? You were here at that time. But
please, lordships. My lordships, he did also. You
were not here.
Please, lordship.
Thank you. Next.
Only one sentence for him, my lords. My junior is saying. Only for him. So then, one important point is there.
One for your junior, one for your second junior.
Well, that training, whether it is post or pre, that training part may be concerned.
Training is not an issue.
Yes. Grateful.
Thank you.
Much obliged, my lord.
Thank you very much for this.
Thank you. Obliged.
Lord, your lordship be pleased to lay down the order of address. We have 3 amicus and present here. I've already filed my brief. I'm happy to start.
Everybody
I leave it to your lordship.
so you may begin. What? Then you will be free. I think how much time will you take?
Me, Lord, since I put everything down in writing, I would like to go very fast with your permission. I don't want to take time over it.
I think then you'll be able to conclude today, so you start.
I beg my lord's pardon.
I said then you'll be able to conclude today, I said.
Most likely, if not,
Otherwise-
your lordship will allow me to continue.
Yes, we are not prohibiting anybody.
Very well. Lord, I would prefer to address the second question first. Your lordship is aware that this reference has been made in 2 stages. The first was on powers under 142 to deal with a divorce by dispensing the period of in a mutual consent divorce or 18 months at the outer limit, whether under 142 a divorce can be granted. In my opinion, my lord, that's a relatively easy question to answer. But my lord, your lordship made a subsequent reference on the question whether irretrievable breakdown divorce can be granted, notwithstanding the fact that one of the parties is not consenting. So,
That
with-
we raised to see, there are a number of cases coming up in court arising from such a scenario. Sometimes courts have exercised, sometimes they're not exercised. It arises at times when parties have been living apart for 15 years, 20 years. You know that there's nothing left in the marriage after so many years. Then should the court exercise 142 or not?
yes,
Or as we framed it, should we hedge the power under 142
yes,
by saying in no circumstance? Or we say, well, 142 power exists, or should be careful in doing so?
that's right.
There will be different degrees at which.
To that limited extent, below, there is an overlap between the two as to how does one look at 142?
Yes.
What are the powers? That is not very well covered
That
ground.
subjectivity also will arise from where it is.
Yes, below, that's a
That will
matter of
always arise.
discretion.
Then discretion will always, not even in this matter, otherwise also, it's bound to vary a little because we are.
Yes, below, from case to case.
We are not a composite court. We are a court of benches. So that
Yes,
will
and,
arise.
and the conception of, at the end of the day, in the interest of justice, what is the conception of the court of justice? Now, my lord, that's why I said the second reference is more significant, because the specific question raised there is, when there is absence of consent by one side, then when can the court use its power under 142? Lord, I would like to carry the matter one step further with your permission, assuming the answer is yes, which in my opinion it is yes, whether even a trial court can do it in exercise of powers under section 151 of CRPC. So there are inherent powers in CPC. Not all courts have inherent powers.
You are seeking to what we have been doing under 142. If I understand you correctly, I'm only phrasing to appreciate your submission. You are saying give powers to the High Court and Supreme
Yes.
Court also under 155.
Yes.
The only, you may, in your own way address it, the only impediment seems to be that despite recommendations of the law commissions, to irretrievable breakdown of marriage.
Yes.
The legislature has been reluctant.
Yes. Right, so both
So
parties.
we don't do 142 like just saying that we grant it. We say, okay, what is that you need? How do you need to maintain? So
Yes, Lord.
it's a balancing which we do.
It is, but my lord, I have, the way I have visualized it is, that, what is the public policy that governs the determination outcome? Now, my lord, it has always struck me as very strange that our matrimonial laws, they tell you what is the capacity to marry, what is the formality required for marriage, what is the way in which you can exit a marriage. But to the best of my knowledge, there are very few judgments which actually give us an idea of what exactly marriage is all about. Perhaps, my lord, it is incapable of definition. And that could be the reason why we don't find too many judgments. So, my lord, the way I've approached the issue is, I begin by trying to explain with reference to case law, how courts have visualized what a marriage ought to be. And then move on to the question that if that is not what the marriage consists of, as my lord put to me, is it dead? Is it an empty shell? Is it incapable of resolution? Then you reach the question, what now do we do after this? So, my lord, it's very important to address the question exactly what, under all laws, under all theories of justice, under all theories of matrimonial law, how does one conceive of the institution of marriage? So, my lord, if you turn to my amicus brief, I put it up. So, my lord, if your lordship turns to the second brief which I handed out today, definition of marriage and law governing marriages.
Yes.
Before answering the question as framed by this honorable court, it is necessary to point out the substance of marriage is a voluntary union that requires consent by both parties. Under some personal laws, the consent is given explicitly, and under other laws, implied. Now, my lord, on a review of the Hindu Marriage Act, I found that there is no specific provision saying that the two parties have to consent. It is only implied from the fact that both of them have to have the mental capacity to marry. Whereas in other laws, my lord, such as Islamic law, there has to be something called kabul, kabul, kabul. That means you're giving specific consent to the marriage.
It's a contractual marriage.
Yes. There is a specific requirement for consent in many laws, but in Hindu law, my lord, it is apparent to me that it's an implied consent because the capacity to marry includes the capacity to give consent.
Yes.
So, my lord, we'll proceed on the assumption that it's a voluntary union in which
The voluntary union, the fact that it's sacramental in character. So when you perform those essential ingredients of marriage, nobody can force you to take a saptapadi, for example.
I presume so, my lord, but there is no specific provision in law
Yeah.
that the party has to give consent. My lord, I have personally dealt with cases where women have gone through Saath Feras. And my lord, one of my clients in this court, while she was doing the Saath Feras, she was sending messages to the police commissioner saying, I'm not consenting to this marriage. And my parents are forcing me into this marriage. I filed an Article 32 petition in this court saying, where is the consent? And it was just, my lord, settled by this honorable court by notice being issued to the parents. And they then agreed that, all right, if she files a petition for divorce, we'll not come in the way. Let the court decide. So, but be that as it may, my lord, let us proceed on the assumption that all marriage laws require consent. That is why I say it's a voluntary union between two people. Now, my lord, what are the implications flowing from this? We move to paragraph 3. All statutes with marriage and divorce, namely Special Marriages Act, Hindu Marriages Act, Divorce Act, Parsi Marriages Act, Dissolution of Marriages Act, Muslim Personal Law, Shariat Application Law, deal with capacity to marry, the procedure prescribed for formation of a marriage, and the manner and method of termination of marriage and divorce. However, strangely, none of them define what is marriage and or what happens during the subsistence of the marriage. Before dealing with the question of irretrievable breakdown of marriage, it is necessary to deal with what exactly is marriage. Now, in other countries, notably below Canterbury versus Canterbury, 1964 Australian law reports. Unfortunately, I was not able to access this judgment. I've taken it as reproduced in a judgment of the Delhi High Court, Arvinder Kaur versus Arvinder Singh. But your lordship may find a copy in the judge's library. I'm not sure whether this copy will be available, but this is what it says. Companionship, love, affection, comfort, mutual services, sexual intercourse, all these belong to the married state. Taken together, they make up consortium. Consortium has been defined as a partnership or association, but in the matrimonial sense, it implies much more than these rather cold words would suggest. It involves a sharing of two lives, a sharing of joys and sorrows of each party, or their successes and disappointments. In its fullest sense, it employs a companionship between each of them, entertainment of mutual friends, sexual intercourse, all these elements which when combined justify the whole common law dictum that a man and a wife are one person. Now, my lord, this...
That's fine.
as I said, this passage is quoted with approval. Just a minute, before I continue. If your lordship focuses on that last sentence, when combined justify the old common law dictum, then a man and a wife are one person. But with respect, this last sentence requires to be dealt with great caution because it comes from the doctrine of coverture in common law, which in fact has been abolished. It belongs to a time when husband and wife could not sue each other, when the debts of one could be recovered from the other, when there were many disadvantages for a woman to be married because she was considered one person in the eye of law with her husband. She didn't have individual rights as an individual. So it has been done away in common law in many different situations, and I respectfully submit, my lord, after recognize the right to autonomy as a fundamental right. It certainly is not the law in India. This is about being one person. So, my lord, yes, a marriage is definitely an association under Indian law, which is monogamous in nature, but it doesn't follow that the two persons are one in the eye of law. That I wish to make very clear. Because if that was the case, my lord, there would be no doctrine of divorce at all. There would be no question of putting a marriage to an end with procedure prescribed by law. And my lord, so therefore, that one last sentence has to be taken with a bit of caution. My lord, incidentally, I've taken it from the judgment of the Delhi High Court in Harinder Kaur versus Harinder Singh. It was a judgment, my lord, which refused to strike down Section 9 of the Hindu Marriages Act on restitution of conjugal rights on the ground that it was unconstitutional. The learned judge held, my lord, that introducing constitutional law into the family was the famous phrase, my lord, quote unquote, introducing a bull into a china shop, close unquote. With great respect, my lord, I don't agree. But I must only tell you this, that the challenge to restitution of conjugal rights is also pending consideration in this court and was listed a few days earlier. So I will not get into that issue. For the moment, I'm just pointing out the source of this this court. Now, there's another quote from a judgment of this court on how do we look at the institution of marriage. And that, my lord, comes from a recent judgment of this court, 2021. Sought to define marriage as follows. A marriage is more than a seemingly simple union between two individuals. As a social institution, all marriages have legal, economic, cultural, and religious ramifications. The norms of a marriage and the varying degree of legitimacy it may acquire are dictated by factors such as marriage and divorce laws, prevailing social norms, religious diktats. Functionally, marriages are seen as a site for the propagation of social and cultural capital as they help in identifying kinship ties, regulating sexual behavior, and consolidating property and social prestige. Families are arranged of a mutual expectation. But I would like to emphasize this sentence. I believe one of my lords was a party to this decision. Families are arranged on the idea of mutual expectation and support and amity that is meant to be experienced and acknowledged amongst its members. Once the amity breaks apart, the results can be highly devastating and stigmatizing. The primary effects of such breakdown are felt especially by women who may find it hard to guarantee the same degree of social adjustment and support that they enjoyed while they were married. Well, this I rely on for two purposes. One, it gives a good description of what a marriage is meant to be. And two, what happens when that amity, expectation of amity is gone. Can you still continue to call it a marriage? That would be how I would address the question, my lord. And if you cannot, then what are the powers of the court to set the marriage legally asunder? Now, my lord, just one comment over here. And in law, marriage is generally considered a matter of status. And it is considered to be a status in rem rather than persona. Because, my lord, it is a declaration to the world at large that you are entitled to deal with this couple as a married couple. It's like a holding out doctrine. You hold yourself out as a man and wife. and you socialize together, etc. And then, as this court says, it has implications such as legitimacy of children, the welfare of the children, and that is why it's considered a matter of status, not just a matter in persona. Similarly, a decree for divorce is also considered a matter of status. It again is a declaration to the world that I am no longer married to this person. So both are matters of persona, rem, and both a divorce decree is always considered a decree in rem. That is the status part of it. So, my lord, one of the sequiturs of this argument would be, why is it that a court of law has to give a decree for divorce? Why is it that I can't agree with my husband that you and I are divorced, and that's the end of it? Because it's a matter of status, because it's a decree in rem. And that is why, my lord, the power to grant a divorce is vested in a competent court of law. So the competent court of law will then look into all these other matters before pronouncing a decree for divorce, because it has ramifications for people beyond the two concerned. All this, my lord, I will link up with my argument that the court ought to grant a decree for irretrievable breakdown, because all the factors that are essential to a marriage have disappeared. They no longer exist. The only question is how to separate amicably. There is no other question for consideration. And of course, the other question for consideration is welfare, more particularly of the wife and the children. I am in strong disagreement with judgments of this court, which seem to indicate, and I believe that the union has filed an affidavit, not in this court, but in the restitution matter, saying that marriage is a sacrament, and it is the public policy of India that we don't break marriages. Well, it is the public policy of many countries in the world.
Two different things. Sacramental is how a marriage is made. Maybe contractual or sacramental. Whether marriage can break or not is not in doubt with the divorce provisions being there in all the things.
Fine.
Now, the issue is that under the Hindu Marriage Act, the divorce is, the whole thing is based on a fault theory. That if you have that fault, you can't take advantage of that fault.
I understand. Section 23, subsection 1.
Irretrievable breakdown would have been a ground reality of the situation without getting into a blame theory.
Yes.
They look too good, and it's many cases we come before the court.
Yes.
Two where we have settled it, we have passed, sent to mediation, worked out a divorce. Two very good people may not be good partners. It's just one of those things. It's not necessary that sometimes we have come across cases where people have even lived together for a period of time. Then marriage breaks down. So being companion is different. Being married in the rigors of the marriage, how it works out are different systems.
Well, I understand that in order to answer this reference, one will have to get into the difference between fault theory of divorce and no fault theory of divorce, without any doubt. But, my lord, it's not such a black and white issue. The way I'm going to present it is there is an overlap between the two. And it's going to be my submission that every marriage where a petition for divorce is filed, and you know from experience, there are allegations and counter allegations. You have never seen a petition in which only one person alleges something and the other does not. There is always that claim and counterclaim by two sides. Then the question comes, are you going to look at the fault theory? Because section 23, subsection 1A specifically says that no party can take advantage of its own wrong. And but not the fault theory in Indian law is smuggled in through section 23A. No person can take advantage of their own wrong. And my lord, sometimes your lordships have used the expression, people who come to court must come with clean hands. That's the limited role of the fault theory. The fault theory has no role beyond that. That's my submission, my lord.
It is also, to my mind, very subjective. What is the fault? See, somebody may say, there are allegations made, she does not get up in the morning and give my parents tea. Is it a fault theory? Or somebody, you could have done the making of the tea better maybe. Then, so, A lot of them are arising from a social norm. Social norm where you think that the lady must do this or the gent must do this. And from there we attribute faults. So this is another concern I have, that what we attribute as fault is not really a fault, but it's an understanding of a social norm, how a particular thing ought to be done.
Changing social.
And
A changing social norms is very important.
very rapidly changing norm. Rapidly changing norm in terms of every couple of years this norm changes. That's the ground reality.
That is why this court has held that public policy is not frozen in time. Public policy, the West Bengal case, the West Bengal, I forget the exact cause title, but in the, where the Henry VIII clause was challenged in this honorable court, which allowed for unilateral termination of a contract. And the question was, what is the constitutional validity of that unilateral termination law? There, the court has gone into the whole issue of public policy and held that public policy is not something static in point of time. Similarly, social norms are not static in point of time. Social norms change. It is no longer possible to argue a case of this kind or any matrimonial issue by relying on the laws of Manu. About that, my lord, I'm very clear. And therefore, my lord, arguments such as it's a sacrament, and therefore, we should not agree to this theory of irretrievable breakdown, do not make any legal sense, my lord.
That's in 1956 on once you, it was sacrament, always treated as sacrament. 1956 we introduced a divorce. Once you introduce a divorce, that in a sacramental marriage, divorce can take place is known. Question is, in that divorce proceeding, should somebody must be attributed a fault, or if two people can't live together, they go for a consent divorce, which was also introduced after some
Yes.
stage of time. Now the third scenario is which, well, you may think the other person is at fault. He can't somehow sit face to face with you and spend time with you. So if the court comes to an opinion that this marriage is not capable of any reconciliation, then there's no point in a actually pointless marriage, which is, as you say, the fundamentals of marriage are absent. And the only other thing is that what terms the marriage should take. You take in, protection and protect the women in whatever way. Sometimes women are actually better off than the men, so they don't even. We've seen cases where they agree that as long as this. I've seen cases where normally the women resist, the man was resisting. I said, what's your problem? She doesn't want anything. She has a better capacity to earn, a better position, but the man doesn't want to let go. I've exercised 142 even in those cases and granted saying that this is being obdurate unnecessarily.
Yeah.
If people have not lived for a couple of years,
Yes.
it works now. Today works both ways.
Yes.
Saying right to resist.
Because the law is
Right
gender
to
neutral.
resist.
The law itself is gender neutral. the law.
Yes.
It will work both ways.
Can we carry on tomorrow?
Yes, and the
Your Lordship, may I please have permission? Your Lordship, Mr. Dave has conveyed his apologies. Also,
The difference we have by for a amicus, I'm sure you can translate it to them.
please, Your Lordship.
Yes, Mr. Sibus. We'll see later. We are very hesitant on intervention because we don't want to.
I'm also hesitant.
Open floodgate of something. So we are not allowing any intervention, but we will get your benefit of your submission.
Since you have launched it. Violations of the government containing the law commission reports. And most of them, all of us will be laying on almost the same thing. The third one, what is left over.
we had quite,
Submissions have already.
Unfortunately, my submission could not be. No, I'm not amicus. I'm for one of the parties here representing.
You are one of the parties.
Yes, no.
Okay, we'll see what you
Petitioners in.
supporting.
No, I am supporting the order. I'm saying that the order under 142 can be passed in cases where there is no consent
There was
also.
somebody who mentioned last time who was opposing it all.
I was not opposing, but I have some suggestions. Yes.
The power and the 142 should be inhibited at all.
That's why the third question which your lordships had formulated is,
That's most,
what is the approach to be?
that's the most,
Many cases are coming of that nature.
Correct.
To find a solution.
that's the most important issue.
And the
question
if there is some submissions which Mr. Sibul wants to make as an amicus.
Thank you.
Like-
Grateful to you.
Sorry. So I will compare today with her. This is Manish. Somebody has given this. This is our.
Compilation, yes.
You can compare. And we'll make a list of what is not there and which is. He said that.
Set your current, thank you.